Good morning, everyone. This is great to get this much energy in a room before everyone's even processed their coffee. We must have a great agenda today. So I'm Johanna Kalb, and I'm the Dean of the University of San Francisco Law School. And we are just so thrilled to be bringing you today's conference in partnership with our friends at the USPTO. So this conference emerges out of this special relationship we have with the USPTO through the Internet and Intellectual Property Justice Clinic. Our clinic students, under the supervision of our amazing Professor Jessica Pfeiffer, become temporary registered patent agents under the USPTO certification program, which allows them to do the real work of trademark and patent law on behalf of clients in the community. We are so grateful for this relationship and the chance that it gives our students to build their legal skills and to bring these needed services to folks who could not afford to buy them on the general market. So I was trying to think this morning about how to characterize the shifts that have occurred since the NCAA NIL policy went into effect in July 2021. And I think maybe revolutionary might be something close. Both for the evolution in law and policy that is continuing to move every day, but also for the impact that these changes have had on college athletics, for schools, for athletes themselves, and for the fans who support them. Today, you're going to have the opportunity to hear about these changes from every one of those perspectives. These big events don't come together without a lot of very hard work, so I want to close my brief remarks before I introduce our co-hosts by thanking our partners at the USPTO and Professor Jessica Pfeiffer and Kenji Yoshino, who directs student extramurals at the law school, but who is also a graduate of USF's sports management program, so he brought a lot of independent knowledge and expertise to thinking about how to build this conference. We also received lots of advice and support from our distinguished adjunct, Roy Eisenhart, former president of the A's, who teaches sports law to our lucky students here at USF, and Larry Williams, who is our athletics director at USF, and who played for my own favorite team, the New Orleans Saints. Finally, I want to thank the law firm of Murphy, Pearson, Bradley, and Feeney, who supports us in many ways, but they also sponsored this conference, which allowed us to bring this great event to our campus. So without further ado, I want to introduce David Burden, the USPTO General Counsel, who we're so lucky to have with us today. As U.S. Patent and Trademark Office's General Counsel, he serves as the principal legal advisor to the Undersecretary of Commerce for Intellectual Property and Director of the USPTO. He also supervises the Office of General Counsel and its three component offices, the Office of the Solicitor, the Office of General Law, and the Office of Enrollment and Discipline. He's a graduate of the U.S. Military Academy at West Point, where he earned a Bachelor of Science in Engineering and co-captained the Army football team as a defensive back, so he also brings some knowledge to this as a former student athlete. He's a combat veteran of Operation Desert Storm, and there's the recipient of numerous military awards, including a Bronze Star. Mr. Burden has a JD from Drake University Law School, where he was a founding member and president of the Drake Intellectual Property Law Society. Over the past 26 years, he has served in a variety of important legal positions, including as patent counsel at Corning, Inc., as vice president and intellectual property counsel, at the Coleman Company as Chief Counsel Intellectual Property at Invista, as Vice President Legal and Deputy General Counsel at International Game Technology, and most recently as General Counsel and Compliance Officer of Gaming Arts. He also spent 2 years as an engineer and 7 years in private law practice. We're so lucky to have him here to welcome all of you. Mr. Burden, the floor is yours.
I have the privilege today of making two introductions. So the first is a close friend of mine. I'm going to introduce Deputy Director Derrick Brent. Now, Deputy Director Brent has the longest title, I believe, in the U.S. government. So I'm going to have to refer to it here because I can't remember it all. But he's the Deputy Undersecretary for Commerce of Commerce for Intellectual Property and Deputy Director of the United States Patent and Trademark Office, or USPTO. He serves as a principal advisor to Kathy Badal, who is the Undersecretary of Commerce for Intellectual Property and the Director of the USPTO. And it's one of the largest intellectual property offices in the world. Having just over 14,000 employees now, we've added patent examiners and an annual budget of more than $4 billion. So USPTO is growing to keep up with all that's going on in this country for invention, entrepreneurship, and the new things like NIL that are kicking in and how that's going to impact things. Deputy Director Brent has served in all three branches of the federal government and the private sector. He clerked for the Honorable Chief Judge Marbley of the U.S. District Court for the Southern District of Ohio, and later served 6 years as a senior trial attorney at the U.S. Department of Justice, Civil Rights Division, where he received a Special Achievement Award for his trial work. Deputy Director Brent also served as a chief counsel in the U.S. Senate, where he handled IP issues along with other areas of law, including constitutional law, civil rights, and judicial nominations. Deputy Director Brent's experience in private sector includes serving as vice president and associate general counsel at Massimo, and he was on the leadership team at Cut Golf and was an engineer at General Motors. Deputy Director Brent received his Bachelor of Science degree in Mechanical Engineering from the Ohio State University, right? You got to highlight that "the." And earned his Juris Doctor degree from Northwestern University School of Law, which now is Northwestern Pritzker University, or School of Law, sorry. So you can't keep up with all this, so many changes. Please join me in welcoming Deputy Director Derrick Brent. I think I've got one more right now. I'm just going to go ahead and introduce also Dwayne Allen. It's great to have you here, Dwayne. He's an American former football tight end who played in the National Football League. He played college football for the Clemson Tigers, where he won the John Mackey Award as a junior and was selected by the Indianapolis Colts in the third round of the 2012 NFL Draft. Mr. Allen spent his first 5 seasons with the Colts and was a member of the New England Patriots in his final 2 seasons. During that time with the Patriots, he made consecutive Super Bowl appearances and was on the winning team for Super Bowl 53. So, welcome, Dwayne Allen.
So you guys can hear us. Yeah. Are we live? There we are. All right. You brought the frigid weather from the East Coast.
I'm gonna take. I can't take the blame for that. This is San Francisco.
No, but it's not frigid. You know? It's like a warm, brisk 60 year round. Can someone turn
The coldest winter I ever spent was a summer in San Francisco.
Yeah.
Mark Twain.
Great quote, not true, right?
It is
often quoted, you know.
Yeah, but it is not true. It is not true. It's a pleasure to be here, Dwayne, and I can't, I can't thank you enough. Dean, everyone here at USF, and the folks who helped to sponsor this, I want to thank you. This is, as the USPTO has jumped into the NIL, trying to educate student athletes as well as to promote the work of the community in helping out in this evolving area of law. It's been really important to have partners like those that are here in the room. It's also very important for you, the students, to get in front of this. It's going to be a great area of practice, and there's going to be evolving issues. As apparently we can't keep one piece of NIL together for more than a week or so. but it's good to be here. I also am thankful that the convention, or that this event has a big man. You know, it's like a big man conference, because between Larry, Dwayne, and myself.
Stop it.
Yeah.
Stop. Big man, and that's. I thought we were talking about CVs. I was like, you're the biggest fan here, okay?
Well, Dwayne, I want to jump in because we're going to have a good conversation, and I think your career is utterly fascinating in terms of the breadth that you covered and the transitions that you've made, and they're very important. You know, you were a college athlete and you played for the Clemson Tigers as a tight end in 2008. I'm happy you graduated before they played the Buckeyes and beat up on us. And but tell us a little bit about your experience as a college athlete compared to today's college athlete, and tell us a little bit about what NIL might have how it might have played a role when you were a college athlete.
Yeah, certainly. Going back to my experience, leaving college, the landscape was, hey, you go on these official visits, you are, courted by all of these top universities. Throughout your junior and senior year, coaches are flying in. At that time, Florida was still hot, so Urban Meyer came through on the Gator jet. Dwayne, you want to be a champion? Of course I want to be a champion. Who would say no? Then you're a Gator. Whoa, slow down, coach. Or Nick Saban, who was new to Alabama, and no one really knew what his career was going to be after, failing in with the Miami Dolphins, right? This new coach, he's coming up. He gives me a call. Hey, Dwayne, we would really love to have you down here at the University of Alabama in Tuscaloosa for a visit. What do you say? I said, and he hung up the phone. I was like, gee, okay, all right, don't want to go there. But was fortunate enough to be a highly recruited. I was the third best tight end in the country. You name the school, you name the coach, they came to my little town. I don't know if you made your way through Fort Bragg, North Carolina. Yeah, most do. But I'm from Fayetteville, so the pawn shop for all of the military that come off base. But everyone came through my small little town to visit me, to offer me the opportunity to go to their school, putting yourself giving you more context. A Bay Area school, sent me a letter of interest. And with that letter of interest, they said, hey, you have to do this essay. Now, mind you, I'm the third ranked tight end in the country. I had a little bit of a big head, but I also didn't have a lot of knowledge on, the college university landscape from an educational perspective, because I was the first in my family lineage to go to college, right? And so I said, whatever, get this school out of here. Years later, Stanford, they want me back. I promise you, they want me back. But the things I didn't have to deal with were worrying about who was the highest bidder. Right? At that time, going into my senior season, I was committed to the University of Georgia. Mark Richt was the head coach at his time. They had a long lineage of tight ends that had gone on, be it Ben Watson, Bubba Franks, Leonard Pope. They unfortunately had a guy named Martrez Milner who came about, who kind of messed that lineage up, but it was cool. I was going to restore it. And I ended up signing with Clemson on signing day, because of intuition, right? Because of being on that campus, being around the people, not really understanding, or better yet, understanding that the circumstances are temporary, but this feeling and how being in that area made me feel is where I wanted to grow and where I could flourish. That was my focus, and I was able to build that intuition. Whereas now, guys have to deal with the same coaches flying out, right, visiting you, the same offers coming through the mail. They now have the challenge even more so of social media, right? I went to school in 2008. Social media was just starting off. So there was MySpace, the beginnings of Facebook, but not the type of publicity or attention that these guys receive now. So dealing with that, and then on top of that, hey, look, make the best financial decision for you and your family blows my mind, the difficulties that they're under.
And one of the things, and it's great, Dwayne pointed it out, one of the things that we find in talking to student athletes today, as well as administrators, is that at such an early age, you have to learn to be an entrepreneur. You really do have to learn the business side. You have to learn things like financial literacy. And these things are very important. Now, I think back when I was 17, and it was enough that I wrote a song and got a copyright for it. And got a copyright, and I thought that was a big deal. But the idea of having to actually start to think about things like your intellectual property and your different things, your trademarks, are you going to incorporate yourself? Because all of these business decisions have an effect on you, not only when you are going to school, but afterwards, if you don't go on to professional athletics, if you want to build your own business as an entrepreneur afterwards. So with that, Dwayne, you've had the professional level and you've had the college level, but tell us, like, what are some education tools that you think are important for high school and college student athletes today in the era of NIL?
I wrote a song and got it copyrighted in high school.
Yeah.
Big man, okay? Big man. Jeez, you just gonna breeze over that like. Yeah, so for those of you who don't know, I currently serve as the West Coast director for the National Football League Players Association. So I oversee, the Seattle Seahawks, the San Francisco 49ers, Rams, Chargers, Cardinals, and anything pertaining to their wages, working hours, or working conditions. I also curate experiential learning opportunities for them so that they can see a little further than I did. And the advice and education that I give my current membership is, or future membership, because we also work with all-star games like East-West Shrine and Senior Bowl, is to be curious while also not being overly critical. So ask questions, right? Like, hey, I love this deal that you did. What are some of the particulars about the deal? What do you like about the deal? What would be some things that you would change about the deal? But also hire competent and capable professionals, right? It starts there. In this fluid and ever-evolving landscape, all right, there's so many different things. The category exclusions and exclusivity clauses, right, are some of the big things that we try to educate our guys on. To look out for, namely, there's a player in my region. I can't get into particulars, but there's a player in my region, this is all public knowledge, who fortunately or unfortunately, right, signed an exclusive deal, during his junior season. He becomes a professional. That contract extends into his professional career. He didn't understand, or he believes that it doesn't, right? The business, of course, believes that it does, right? Like, also educating them that the businesses that they're doing business with, right, it would be bad business on the business part to not look out for the business best interest. It should be the players in the players' best interest to look out for their own best interest, right? So understand that, hey, look, while they're smiling in your face and shaking your hand, this is a business transaction and they're looking out for their best interest. So make sure that you hire a capable and competent team to help you be curious, but not critical over things.
A couple interesting points off of that, and one is, and some of you may remember this, Grant Hill, when he came into the pros, I think you know what I'm about to say. Grant Hill made an interesting move. Rather than hire a sports agent, he actually hired an entire law firm. He hired Arnold Porter. So instead of having someone that was taking a percentage of his contracts, he was actually just working by billable hours and actually saved money and had a firm of 400 and some odd attorneys working for him on all of the issues that would come up. So he was very well protected.
Right. Even now in this space, right, like marketing directors charge 20%, right? Like now, as it pertains to, your legal representation as for agent contractors, right? Like we set limits to protect the players, so that's capped out at 3%. But like the marketing, there's no set limit for marketing agents to take advantage of these players.
Next thing you know, your profit margin is gone, and by profit margin, I mean basically anything you're bringing in, you're paying out.
Yeah.
The other interesting aspect, and Dwayne, I share this with you. I was the first in my family to go to college, let alone law school, and it's a moment of pride, but it's also an eye-opening experience. You get there, and there's all this stuff. I remember my first day at Ohio State. I'm going to class, and we were 62,000 students at Ohio State. So I'm walking up to my 8 o'clock Math 150 class, and I look over at someone and I say, "Hey, do you know where Math 150 is?" And the guy looked at me and said, "How would I know? I'm not in that class." And I'm like, "Oh, wait a minute. This isn't like high school anymore where everybody knows where everybody is going." But to get back to NIL, this is a really interesting. This is one of the parts of why it's important for events like this, for folks like you, not only to get educated, but also to educate others, because it's the families. We still have generations of folks that they're the first in their family to go to college, and as they're going through this athletic experience, and I know my friend out here, Wayne Stacy, who's going to be on a panel later. We've had this discussion. It's important for the families to get this education and to learn about intellectual, things like I said, intellectual property, trademarks, rights to publicity. My man Jason Lott over here is going to give you a chapter and verse later on today about that. But educating the parents is as important as educating the student athlete to be an entrepreneur, some of the business sides. So that's really important.
And we host programs. It's called this core program, where we reach out to the families and significant others to hope that there's some sort of trickle down effect where, the players in season, is kind of hard to cram any more information into their heads whenever they're going out week to week to put together the best game plan. So the hope is, by engaging the family members, that they are able to absorb some of that information.
See, that's great. I mean, it's necessary, and it probably stuns people that in this day and age you're still, but when you engage with the athletes, you find out like there's still a learning process.
Huge, and again, in this evolving landscape of NIL, where schools have honor codes, and Larry, good to see you, man. I was like, who's this guy scowling at me? Oh yeah, good to see you, Larry. How's it going? Good to see you. He's locked in. That was you focused, not scowling. All right, just saying. But in this ever-evolving landscape, it's important for these guys to understand that, it's unfortunate that these guys really have to understand. And what I mean by unfortunate is college was always this space where you could learn about who you are, whose you are, and who you want to become. And unfortunately for these young athletes now, more and more pressures are being thrown on them, and the expectation is going to be, unfortunately, you knew who you were and you partnered with this company when you were 17, 18, 19, and now that you're 28, don't want to associate my business with you, right? That's the unfortunate thing, but the more that we are able to educate them and prepare them for the opportunities ahead, hopefully the better they are.
And one of the great parts of this conversation is it kind of level sets the background and the landscape that student athletes, and I call them athlete entrepreneurs, that they're operating in. Dwayne, you one of the biggest transitions you probably made in your life was as you were going towards the end of your football career, that you had to learn business. And in fact, even when you transitioned into becoming a professional football player, you had to learn the business side of the sport. And eventually, as you transitioned out, you had to become more of a business person. Can you tell us a little bit about that? How you educated yourself, on the business side of sports?
Yeah. So Monday, I was at this really cool business dinner hosted by the Arizona Cardinals, myself, an organization called PAC, Pro Athlete Community, that works on educating professional athletes about business and other opportunities. Was there the NFL side, Usama Young, my brother, he was there as well. And Larry Fitzgerald was our keynote speaker and gave a fireside chat. And, Larry, he meant well. I promise you he meant well. But he gave this example of him in year 9. Those of you who are not familiar with Larry Fitzgerald, he will be a Gold Jacket, a Hall of Famer in the NFL. He is number 2 in receptions, yards, number 6 in touchdowns or something like that, all time in the NFL. And so he was the 3rd overall pick in the old CBA, where, those guys really made a lot of money. And then he had a lot of success early on in his career. So he's telling this story from year 9 in his career, where Old Spice, and the gist of the story was, hey, look, know who you are and, stand up for who you are in these business dealings. But here's what was communicated, in 2012, Old Spice came to me and they wanted to do a deal with me, and they offered me $1 million and said I had to get into this chicken suit. And so I was like, no, I'm not getting in that chicken suit. So I followed Larry and was just like, Larry, if Old Spice offered me $1 million to get in a chicken suit, my brother, cluck, cluck. Okay? Okay? How I expanded on that was, hey, bro, you got to be who you can afford to be. Right. And, if there's a gift that I have, it's self-awareness. Coming into the league, I understood that I was the first in my family to go to college, understood that, my first in my family to ever even dream about the amount of wealth that I came into. And so I was just patient. A mentor, business mentor once told me, hey, time is a poor substitute for money and vice versa. And I knew at that time, pun intended, I needed more time to learn, more time to better understand, the ramifications of my financial decisions. And so I leaned on other business professionals. I was curious, right? I hired a team around me to help me make some of those decisions, but also, and most importantly, educate me. One of the things about my team is if you're not educating me, right, then you're taking the decision away from me, right? I never want that agency taken away from me. And I'm not one of those managers where I want to do everyone's job. I at least need to have a basic understanding of the decisions that's being made, so that, because no one's going to care more about your money than you. So I educated myself and was curious, man.
There's a lot to curiosity, right? Just asking people, having conversations. Oftentimes, like when I'm talking to law students, and if they want to look at my long and winding road of a career, but sometimes they'll say, what advice do you get? And I say, talk to people. Just keep talking to each other. Learn what your friends are doing. For my law school, I'm a pretty easygoing guy, as you can tell. And so, like, for my law school class, there were about 200 of us. And I still stay in touch with probably 60 of my classmates just along with others in the years around me. So just but staying in touch with them, whenever I wanted to make a pivot in my career, when I decided to go into civil rights, for example, and to learn what the Justice Department was actually like, what it was like to work, I started talking to people who were at the Justice Department. I talked to another person, and then, gradually, this is something something I'd be interested in. But that curiosity plays over into the business side. Learn from business people, sit down and talk to them, just an informational conversation. And then to the practitioners that are in the room, this is where the student athletes and their families, and not just student athletes, but the high school athletes, they can learn from you. Old school law practice used to be that we would sit down and for a half hour just talk to somebody for free. If they got to be a client, great. If not, well, we'd help them along in their journey. And I know that in the, while we're all under billable, I'm not under billable pressures, but for the practitioners that are under billable pressures, that half hour is still pretty meaningful to talk to someone or talk to their family and to give them a little bit of education. And, one of the things that comes up, because especially in this world of NIL, are those little deals where someone wants to have your rights. Like you mentioned the one situation, and but there are many out there. It's just a little clause in there. By the way, we own your intellectual property, your rights, or your right to publicity, your right to your likeness. We own it for the next 10 years. There's the, and again, this is public knowledge. There's the young man from Florida, or who was in Florida, signed an NIL deal, and then he went pro. But they said, okay, great, but your NIL deal continues, and you actually owe us, a royalty. And there's a whole battle about it now in court because of the fact that I think Florida has a law. There's a whole choice of law provision. I won't get into the geeky side, but there's a whole question because Florida had a law that your NIL deals can only last while you're in school. So this again is the landscape of why it's important to know something as simple as what are your trademark rights? What's your right to publicity? But Dwayne, in your experience, you've seen a lot out there. Have you seen any types of either things that student athletes or athlete entrepreneurs should be wary of, the types of deals or types of offers and things to be aware of in terms of their rights in particular?
Yeah, be wary of everything.
Yeah, exactly. Keep your head on a swivel, right?
I know. And yeah, definitely keep your head on a swivel, but be wary of everything and hire the competent and capable professionals that are going to look out for your best interests, right? That is the information that I give to our active players, right, and to our future players. The businesses, it is great business practice to look out for your business best interests, right? And these athlete entrepreneurs are businessmen. I like that. That's one of the things I like to educate them on as well. You're a business, bro.
I'm not just a businessman. I'm a businessman.
I like that.
That's one of my favorite lines. I was speaking at a Department of Commerce event, and I was talking to a bunch of entrepreneurs, and I said that line, and as I was walking back, one of the other undersecretaries stopped me on stage as I was going to my seat. He said, "Did you just quote Jay-Z?"
I did.
In the middle of an official event, I was like, I learned from my judge who one time quoted Tupac on the record in a court case. Dwayne, as we close up here, we're reaching close to time. But when you think about this, and maybe talk a little bit to practitioners. What would you like to see practitioners approach? Lawyers and so forth. How would you like to see them best approach athletes in order to form that trusting bond?
Wonderful question. Come ready to educate, right? You're the subject matter expert, right? And though I'm sitting up here, right, the conversation I had with our in-house counsel, Andrew Morris, about this topic educated me even more to come and speak confidently on the things that I know, but he really knows, right? I consulted that subject matter expert, and he was able to educate me even more, right? About the 32 different states with NIL laws, right? And the various cases that are going on around the country, right? But come with an educator mindset, right? And if you are not under billable pressures, right, spend that time to educate, because it does take time to really get that trust. And these guys giving you a little bit of how they think, right? Everyone has been coming after them for something since they were 16, 17, right? It is exhausting. So to meet with someone that is actually bringing them great information that's going to put them in a better situation over a period of time, right? I don't know if that's going to take 3 conversations or 10, but you coming and adding value, like everything in life, right? Over a period of time, all of a sudden, you're going to reap the benefits of that sacrifice.
That is great. That is great. And I'm looking at my timekeeper. How am I doing? Okay, great. We got 5 minutes, and that's great because I do have a follow-up. And Dwayne, maybe you could share with us some of your experience as an entrepreneur, as a business person. Talk to us a little bit about your entrepreneurial pursuits and any dealings you've had with trademarks or any other types of intellectual property.
Look, when I saw that question, I said, "Are y'all using? Have y'all been doing searches on me? How dare you guys use the government, the tax dollar?" Yeah. So finishing up my athletic career, again, I got bored, right? It wasn't one of those things where I was cut and done or I was injured and could no longer play. It was more so one of those things where I was bored and ready for my next challenge. I see life as a mountain range, not as one mountain. And so as exciting as it was to charge the mountain of professional football, and before that, the mountain of college athletics, and win the John Mackey Trophy and be an All-American, and then go on and do all this great stuff, it was like, all right, cool. That's one life, and that was really cool. But like Larry, I want multiple lives, right? What is this next life going to be for me? And so I had an idea, and I was like, oh, cool. What do you do in an idea? Really good kids book. Like, what do you do in an idea? Anyway, for those of you with kids. And for me, I know that I have a heart of service, and I wanted to utilize ideas to serve others. And so went down this path, and I got to a point where I didn't have a large enough network, and I didn't have enough information. And that's when that mentor of mine thankfully gave me that great tip of, hey, look, time is a poor substitute for money, and vice versa. And I was able to recognize that I was at a point in this path where, hey, look, the idea needed more time, right? I needed more time to build the network. I needed more time to better understand the problem that I'm solving for. And the idea, the problem itself needed more time to grow to the point where it was valuable enough to investors to come alongside me. And so a pivot came about, and the National Football League Players Association gave me a call. I was a rep during my 8-year career for like 6 years, and they asked me if I would be interested in being the West Coast director, to which I said no. Like, I'm free, leave me alone. But then a friend of mine was like, hey, look, you love serving people, you love knowledge transfer, right? Like, I think this would be a really good opportunity for you. And man, it's been 4 years, and I'm enjoying the ride.
It's one of the things that comes, maybe it's a lesson from team sports or from other aspects of our lives, but serving something greater than yourself. And Dwayne is a shining example of that. One of the things in looking up his background, I saw that he was doing youth camps after he graduated, going back to his hometown, and he's always had a heart of service. And I think that's a credit to the work that you do.
Man, thank you for that, and it's a credit to the really good people that I've been fortunate enough to surround myself with, but not intentionally. They came around me at just the right time, so I've been very fortunate. But in that, it's anytime that I don't know what to do, I serve. And you know what? It comes to me. Like, the opportunity comes because I choose to serve others instead of, selfishly sitting in whatever frustration I am about a decision where I don't know which way to go. Okay, let me get it off of me and let me take care of other people, and I will be okay, right?
Amen. Well, listen, thank you very much for the conversation. Folks, this is going to be a great day of conversation about NIL, and this was hopefully a good level set, a little appetizer for things to come as we get into some of the details. It's an evolving landscape, and we at the USPTO are very happy and excited to be providing resources and knowledge in this area, and you'll hear from some others about some of the additional resources that we have out there that we're looking to deliver. Dwayne, thank you very much.
So excited. Thank you.
Okay, so welcome to panel one. What an amazing first conversation. I love this theme of knowledge transfer, which is why we are here today. Okay, so panel one will be on NIL Basics. I am Jessica Pfeiffer. I am the director of the Internet and IP Justice Law Clinic here at the University of San Francisco. Just a quick disclaimer, this is educational content only. We are not giving legal advice, and any opinions expressed today are those of the individuals themselves and not their respective institutions unless otherwise stated. Okay, so let's meet. I had to do the disclaimer. Let's meet our all-star panel team. We have Professor Casey Faucon, Dr. Molly Harry, and our athletic director, Larry Williams, here at USF. And I must add that he was drafted by my favorite football team, the Cleveland Browns. Can you each give us a little bit of background on yourselves?
Okay, are we good? Again, Larry Williams, thank you so much for the hospitality and inviting me to join you. This is a particular interest to me because as I was going through my career in the NFL, I went to law school at night. And when I graduated, I was still playing and trying to figure out what to do. I ended up finding a law firm based out of Indianapolis that had a sports law practice. And as all of you know, the means by which you monetize assets in the sports world is intellectual property, right? So it's trademarks, copyrights, right of publicity. So I was fortunate enough to fall into an opportunity to do that for a large firm, and I did that for about 8 years before becoming an athletics director. So I'm thrilled to be here and start to hear Derrick talking about what the USPTO is doing. I was having flashbacks to my time practicing law, but yet this is so important in today's world of college athletics. I can't begin to underscore it strongly enough. This is going to reshape the next 100 years. We're going to get into some history today about the development of intellectual property as it relates to NIL, and it's really been somewhat stagnant over the course of the last 100 years in college athletics. But now it's really going to start to change, and you guys are jumping in at the inflection point that's really exciting.
Great. I'm Molly Harry from, there we go, University of Florida. I grew up around sports. My dad's a former sports journalist, so I'm very passionate about all things college athletics and professional sports. I study the relationship between the NCAA institutions and conferences, primarily looking at who's at the center of that, being the college athletes and their rights and well-being, with name, image, likeness being one of the most powerful movements for their rights and having impacts on their well-being, both positively and negatively. Looking at that, also looking at potential for employment status and house case ramifications. So that's sort of my intersection here.
So hi, everyone. My name is Professor Casey Vaucan. So I currently teach at the University of Connecticut School of Law, and I direct a transactional law clinic there where we help small businesses and entrepreneurs as well as student athletes with their transactional legal needs. But how I got started doing NIL work was I used to teach at the University of Alabama Law School. I was there for 5 years. And in 2018, we had an opportunity. We were approached by the athletics compliance department because some of our quote unquote elite football players, and I use that terminology with some hesitation, but understanding that it is the industry term, and so I'll use it in this context as well, because they were having issues with third parties, private market parties misappropriating their name, images, and likenesses. So we had an opportunity to represent the football players in front of the USPTO to protect against the misappropriation. And then in about 2018, 2019, we also had another, I'll call it opportunity, to try and be a little bit more proactive about how we might be able to protect a student athlete's NIL through the USPTO's trademark registration process. And that's how I got started doing this work.
Wonderful. Okay, let's get right into it. So up until July 2021, the NCAA has restricted student athletes from profiting off of their NIL. But what does this really mean? What rights do we have as persons, regular people, in our name, image, and quote, likeness? Professor Vaucan, can you kick us off?
Sure, I'd be happy to do that. So we talk about NIL rights, but we're really talking about interchangeably what we call the right of publicity. And the right of publicity actually stems from a larger state right, and that's the right to privacy. And there's sort of different prongs to what the right to privacy entails, depending on how public of a person you are. But the last right that's covered under the right to privacy is the right of publicity. And how the right to publicity is different than all of the other privacy rights is that it gives the holder of the right this commercial advantage. All right, so it's not just that you have a right to sort of be free from nosy intrusion from the public, but also that your name, image, and likeness has a commercial value. So if you are the holder of your NIL right, your right to publicity, like all of us individually are, you have some rights that are attendant to that. Now, it's on this. I think it's on the slide. I do want to mention, so the state right to privacy, that sort of overarching umbrella right that covers the right to publicity, it's a state-based right. Okay, there is no overarching federal right to publicity that exists. So you see, when we talk about different sort of NIL rights, for example, it's in general what rights exist within each different state, and we'll talk a little bit more about that, I think. Yeah.
Okay, so let's talk a little bit more about what each of these really mean. Name, image, likeness.
Oh, sure. Okay, so when we were talking about NIL, that acronym is short for name, image, and likeness. So it includes not only an individual's name, but it could also include nicknames and names and terms and phrases that are identifying to your persona within the commercial space. It also includes what we call images. So that's a photograph of you, your likeness, your image in the use of a TV broadcast or in the use of a video game. And I know that Larry's going to talk a little bit more about the broadcasting rights and some of the value that lies within there, but also the use of your image within commercial appearances as well. Okay, and the last one, so likeness, it's a little more nebulous, but it's not just your actual sort of real photograph of yourself, but things that personify you. And it could include like a digital bot of you. The case that I like to talk about a lot is, we call it the Vanna White case because it was a robot that was sort of placed next to what was clearly the Wheel of Fortune. And so anybody watching this commercial would know that this robot sort of had the likeness of Vanna White. So it includes sort of personifications as well.
Thank you. And I just would like to add that today with AI, that this becomes much more important because it's so easy right now to be able to replicate anyone's likeness. So just keep that in mind. Okay, so let's give a few more examples of what's included in the right of publicity. We have these 3 buckets here: the endorsement right, merchandising entitlement, and right against virtual impressment.
Sure. Okay, so remember I said a little bit earlier that the right to publicity is a state-based right. So when we say that it comes with these sort of bundle of sticks, these bundle of rights, if you have legal training that comes from property case law, in general, it has these 3 things that's included with it. And the first one is what we call the endorsement right. So the ability for you to have the right to determine how your NIL is used to endorse a particular product or another brand. So the next one, we call this the merchandising right. So you have the right to determine how your name, image, and likeness is used on apparel and merchandise that's sold. And this we see a lot of in the student athlete space in terms of not necessarily having their consent to sell apparel that has their NILs on it. I mean, this is how I got started doing this work. And the last one is the right against virtual impressment. So again, the ability to choose how your digital image or your TV broadcasting rights are going to be used, and who has the permission to do that.
And the slide does say, it says doesn't include broadcast rights. That means right now athletes are not getting compensated for their broadcast rights, which we will talk a little bit more about. And just quickly looking at the overlap of right of publicity with other forms of intellectual property. So specifically here, we're talking about trademarks and copyrights. A trademark is a source identifier. Think about it as a brand name. So you could see how the right of publicity your own name can become a source identifier. And so if that's the case, if you're using your name in order to sell merchandise, then you could perhaps file a trademark application. And Jason Lott, please stay for his panel if you want to learn more about trademarks. And then also there's overlap with copyright. Copyrights are the original creative works. And so here is a picture of Simone Biles, and whoever created that picture would own the copyright. It's not Simone's copyright, but here, Simone does have the right of publicity. So if the copyright owner is going to sell this picture, then Simone should be able to stop that. But on the flip side, Simone wouldn't be able to use the copyright without the copyright owner's consent. So you see the overlap here with other forms of intellectual property. Okay, so let's move on. You had mentioned that this is a right of publicity is a state right, and here is a map taken from Open Doors. You may have seen this map before. It's a relatively recent current state of the NIL legislation as it relates to student athletes. So can you talk a little bit about what we're seeing amongst these states? It doesn't look like there's uniformity here. Maybe can you tell us some of the commonalities that you're seeing?
Sure. Okay. So we have a lot of state movement since 2019 when California was the first to enact the Fair Pay to Play Act, which some of you might be aware is a bit of a misnomer, but how it's actually turned out in effect, it's actually pretty accurately named. But other people are going to talk about that later on today. But so we have a lot of copycat statutes. And what is really great about student athlete NIL rights is they are still occurring at the state level. So we've had about 8 federal bills that were proposed, but none of them had enough support to actually move forward and become federal law. So right now, states, as it within the purview of state legislatures to do, are stepping in to say we would like to protect the NIL rights of our student athletes. It is a state-based right. So most of them in general basically bar an association. So that would be here pretty much directed at the National Collegiate Athletic Association. It bars a association and a university from punishing a student athlete from receiving revenue from the use of their NIL. It allows a student athlete to hire licensed agents and attorneys. They usually subject the student athlete's NIL deal to the school's conflict of interest policy. So if the school has a larger sports drink endorsement deal, for example, a student athlete might have some issues if they want to sign an NIL deal with a startup sort of health sports-based drink, for example. So there's some issues I see there, but that's for later, I think. And then the last one, a lot of the statutes provide the student athletes or require them to have some sort of mentorship and financial literacy classes. And this was, I think, for me, looking back on it, I'm a little surprised by it. Okay, I think it's necessary and it's useful, but you don't necessarily see state legislatures requiring this type of financial literacy from a particular constituent group. Like we wouldn't do this for like influencers, for example, or 19-year-old tech startups that raise sort of large amounts of money. We just assume that they have that already. And also just as someone who is an academic and is coming from the university perspective, like we should be doing that already. for all of our students. So I just find it, a little odd that for some reason in this context, we think we needed to pass state legislation saying that we need to educate our student athletes on financial literacy. And I'll leave it up to speculation as to why we think that in this context.
Can I add to this? So I'd also like to point out that many states have repealed their laws, and there's a thought, particularly, again, coming from a scholarly perspective, that in a practitioner lens too, that the more free your state is when it comes to NIL legislation, the more rights athletes will have, and that makes it more appealing for an athlete to attend a university in that state, because there's less restrictions on what they can and can't do when it comes to NIL, potentially offering them more financial opportunities and compensation. I'd also like to point out as well, because this is a state-based right, the NCAA and others have come forward really promoting the idea of federal preemption, a nationwide state law regarding NIL, but with its connections to the right of publicity more broadly. What does that mean for future right of publicity law if we just do that for NIL with college athletes? What does that mean down the line? So I think this map and what athletes are allowed to do in each state, and the idea of federal preemption is really important when it comes to this.
Great. Okay, so a little bit of a wordy slide. Apologize for that. But let's talk just a little bit more about some discrepancies in state law, and also how does the First Amendment come into the mix? Sure.
Okay, so there's about 40 different state statutes that we can look at for differences. And we talked a little bit earlier about ways in which they're the same. But there are, and Dr. Harry was bringing this up, there are certain factors and differences in each of the statutes that might make a student athlete go to a particular school, for example, or to school in a particular state because of this. Because remember, if you're a student athlete, you have all these different layers of rules that apply to you. You've got your school, and then you've got your conference, and then you've got the NCAA, and now we've got state law. And maybe one day we'll have some sort of federal legislation, but we've definitely got like case law that we're subject to under like the Sherman Antitrust Act, right? That's what the Alston case came up under, right? So for now, we've got a few different discrepancies. And one of them that I want to really talk about is the third one, so the restrictions on the different types of endorsement. So normally outside of this context, you would be free to endorse any type of product, right, that you would want to, right? You can put your NIL on any type of product, but depending on the school that you go to, this is either in the state statutes or it's in their internal policies. They'll have some limitations on what types of businesses you are allowed to endorse. And a lot of them in general are, we call them the vice industries. So tobacco and alcohol. And I think now they have e-cigarettes, sports gambling, and betting. And then in some states they have things like homework assistance. You can't promote homework assistance programs, for example. Anything that might be sexually oriented, right? Some schools have completely eliminated those, right? So you have to disclose your NIL deals to your university, and someone has to make a call as to whether or not it either conflicts with your larger, sports drink promotion, or whether or not it falls into one of these like vice groups that we want to prohibit, and I'm not as much of a First Amendment scholar of the aspects to it, but normally those would be rights that anyone would be able to exercise, right?
What about the institutional involvement in NIL deals? I know that Senator Skinner, she released a statement stating that California schools, the Fair Pay for Play Act has always allowed schools to facilitate these NIL deals. So what do you think about that?
Well, I think we're getting close. We're still 6 months away. And from a practitioner standpoint, this is a really frustrating point in time. Many of the restrictions that we see in various state laws really relate to trying to create a balance between the rights of the university and the need to make money to fund all of the sports activities and the fair rights that the individual should have as a student athlete. So many of the opportunities that the university has to preclude a deal that a individual will get into simply protect existing deals that the university has already cut. So we've got these two trains going down parallel tracks, and every once in a while the tracks cross, and it makes for a real difficult landscape within which to work. We want to support our student athletes. Again, we want to recruit the best athletes we can get, and so we're trying to make sure that we present an open field in front of that train. Within 6 months, my hope is that with the House settlement and perhaps some movement in Congress now that the election has occurred, we're going to start seeing opportunities for the universities and the student athlete to work together to identify sponsorship opportunities that lead to revenue for the individual student athlete, but also for the student. That powerful combination is far more valuable than individually each going out to the market separately. Think about a student athlete. When I was a player, I was an offensive lineman and not well known at all. But it was hard to generate any type of commercial interest in me. You know, a big unknown guy behind a face mask. But in combination with my employer, be it the Cleveland Browns or later in my years, the Saints, it was a far more powerful proposition. And I would have loved to have gotten into a couple of deals with an organization. Those opportunities are down the road, as I say, about 6 months. I've used a few too many words here, but I'm anxious to get into the new world where we can work together to try to correctly monetize the rights of both entities. Fair?
Fair, exciting.
Can I add
Yes,
something too?
please.
So in many Division I, Power IV now institutions do have directors of NIL strategy, whatever they want to call it, and they do sort of act as this middle person between the athlete and a company. We had for the University of Florida, we have a director of NIL strategy. He oversees every sport besides football and with their NIL deals. And for example, a company came to him and said, "We are doing a video on women in STEM. Do you have any athletes? We want to send them up into a zero gravity plane and have them promote this idea of women getting involved in science, technology, engineering, and math." And 3 of our women's athletes went up into this plane, were on this video, got compensated $1,000 a night in a hotel room, all these cool things. So there are really cool opportunities, but that does look different based off what your state can and can't do. And Florida has a policy that might be a little more lenient compared to some others.
And I just want to add, the right of publicity needs to be balanced against the First Amendment. So, if someone's using your NIL in connection with news or broadcast, even a parody or satire, then it's going to be balanced, and you may not be able to restrict that type of use. Okay, let's get into the fun stuff. So a lot of the NCAA rules revolve around preserving this principle of amateurism. So let's talk a little bit more about what that really means and whether you believe the current NIL policy is sullying this principle.
Oh, I'll jump in on this one. So a colleague of mine did some research as we're getting ready for NIL and came across a pretty fun fact. Anybody remember the name Jim Hogan? No, I don't imagine so. Jim Hogan, though, at the time, the turn of the century, 1901 to 1904, was a heck of a football player. Heck, so good that Yale University really wanted to recruit him hard. He was a wonderful student, made the honor roll, was captain of the debate team, quite an individual, but quite a football player, and he got quite a deal. Not only did he get a stipend from month to month to participate, but he got the license to sell cigarettes, an exclusive license to sell cigarettes to the entire New Haven community, including the football stadium. What a deal, right? And at the end of the year, they sent him on a all-expense-paid trip to the Bahamas. Think about that in 1904. That's a pretty good deal. So we went from that point in the turn of the century to about the middle, say the 1950s, when the focus became, hey, we really need to protect the amateurism model and focus on and lend more credence to the academic pursuit of these individuals. It was becoming far too athletically oriented. So it was about the 1950s where we started to see these amateurism rules start to really take place. Lo and behold, we're now 120 years away from old Jim Hogan, and we're right back to the same place that we were when we started. Really interesting. But what we have to do now is find a new balance between restricting a student athlete's opportunity to make money on every right that every one of us has, their name, image, and likeness, and we've got to do it in a manner that's far more fair between amateurism and full. Let's call it full fair, free market, because in order to run an athletic organization, there have to be rules, right? You have to have rules to every game, and indeed to have competition, you have to have fair competition. Otherwise, it's just not very interesting. So there will be a point in time, and I think all of the practitioners in here might be able to lend some help in to figure out what the new world of amateurism looks like, or the new definition for student athletes' participation in collegiate athletics is. My fondest hope as a practitioner and a lifelong student athlete is that we don't lose the connection between academics and athletics. That's my biggest fear in all of this, that it becomes completely commercial and we yet become minor leagues for the NFL, NBA, and Major League Baseball. That doesn't fit on a college campus, nor does it fit for the long-term good of students that are on campus that want to play at a high level. So anything that you can do, I'm going to put my plea in here to all you practitioners, anything you can do to help preserve the academic component. How we pay for it, who cares? We could figure that out. We could beat up the details, but we got to preserve that academic and athletic combination in order to continue the great outcomes that have happened over the course of these last 120 years. So I went a little bit off topic, but amateurism, while it served a great purpose for quite some time, I think with so much money now in the system, it's only fair to make sure that we evaluate how we're balancing this.
And I'll say, I think a big point from Larry's comments is that amateurism's been sort of fraudulent and contentious since the beginning. If we adopted amateurism, depending on the historical document you want to look at, 1916, 1922. If we have athletes receiving compensation to go to the Bahamas, we have athletes long receiving under-the-table payments. This idea of an amateurism or an amateur has arguably never really existed. This is not NIL's fault that they are no longer amateurs. This is the fault of the system that we now have great opportunity to try to preserve, change, and have athletes and their rights be at the center of that. So that's my critical scholar perspective of the definition of an amateur. Yeah.
Amateurism did work for me during college. I couldn't get a pizza. So for many years, student athletes lived under it. Now, be it the folks down at SMU or otherwise might have tried to skirt around the edges of it, but indeed so many young men and young women have lived under the benefits and the challenges of the amateurism rule, and it's great that we're finally taking the lid off the top.
So interesting. Okay, let's delve deeper into the evolution of NIL rights for college athletes. So you could see here a rich history of litigation with the NCAA, but so both courts and states alike have been chipping away at this really strict NIL policy that eventually led to July 1st, 2021, the NCAA policy change, and maybe will lead to a House settlement. So I do want to spend a little bit of time fleshing this out.
I can kick us off here. I go over this with my classes. It's one of the best topics, I think, and one of the benefits of our first panel here. So we have these strict amateurism guidelines from the really the early 1900s up through the 1970s, early 1980s, or this idea. Larry and I are going to disagree on amateurism, and that's great. That's why we're here to discuss this, right? But we have the adoption of athletic scholarships in 1957. So before that, it was only need and merit-based aid, academic-based aid, et cetera. We have this adoption of the athletic scholarship, which allows this idea of the student and the athlete. And during this period, we also have the creation of the term student athlete, which goes down a rabbit hole, but I encourage everyone to look that up if they have time here. So we have this adoption of the athletic scholarship, the preservation of the student and the athlete duality piece there. 1984, the Oklahoma v. NCAA case here, where this really expands or explodes commercialism in college athletics. So previously, the NCAA held the rights to mainly football, television. So basically, each region only had 2 football games on each Saturday, and that was all that was on TV. And I can't imagine that now. I love College Game Day. It's on from the time I get up until I go to sleep at night. Used to be Pac-12 After Dark. Don't know what that is now. But so this really opens up, and they rule in the school's favor. The Supreme Court does that. Schools have their rights. They then market those off to the conferences, and now we have what we have. And this allows for commercialism to take hold. And NCAA President Miles Brand in the early 2000s said, amateurism describes the athlete, it doesn't describe our process. And I think that's a result of this commercial boom in the 1980s. We have the O'Bannon case in the mid 2000s, and it's interesting, and the lawyers on the panel can speak to this violation of antitrust law, and now, but we'll just compensate you with cost of attendance. And that looks different, obviously, at every institution, right? To live in Gainesville, Florida looks very different than to live in San Francisco, California. So those cost of attendance stipends vary based off of institutions. And originally, when this was adopted, coaches, athletics administrators, et cetera, were really nervous about what this would mean, because it could be seen as a recruiting inducement. I can go to San Francisco, a school out here, get more cost of attendance paid for, versus going to the University of Florida, where there isn't as much cost of attendance there. And that turned out really not to matter. Athletes go to their schools for athletics, hopefully also academics, et cetera. They're not really concerned in that way. I don't need to keep talking if someone else on the panel wants to take SB 206. No? No.
You're going.
Oh, okay. Yeah, okay. My teaching hat's on. So SB 206 comes out 2019. We, of course, know that all these other states start to follow suit. Again, with that idea of it being a recruiting advantage to get athletes. If the California athletes are able to make this jump and receive this extra compensation, we need to get on board, because we want those athletes too. We know that the state of California has great athletes. So particularly state of Florida, and I believe Georgia also filed to have their law passed July 1st. 2021, we have the NCAA adopt NIL June 30th, 2021, right before that. So depending on how you look at it, did the NCAA do it because they wanted to, or because their hand was forced, right? And we see a lot of individuals, particularly Mark Emmert. I've watched all of the NIL panels and testimonies to Congress, all 12 of them, hours upon hours. It's say time and time again, we need more time to figure this out. And me being, as you might know by now, you had 120 years to figure it out. So that's my personal opinion. We have the Alston case here. Again, another instance of antitrust coming into play here. And this allowed athletes to get $5,980 per year related to academic expenses. And again, this varies by institution and what that might look like. I was at the University of Arkansas before the University of Florida. They attend one seminar each semester and they get their check. At other institutions, you need to maintain a certain GPA. It's much more rigorous. But again, the intent behind that, with education being at the forefront, I would argue has really fallen through the cracks in this process here. We have, again, the adoption of name, image, and likeness. With their, the NCAA came out with 5 bullet points on how to monitor NIL for schools and athletes to to understand, and that has since evolved over time. October 2022, they released a new, much more thorough guidelines which address collectives and how institutions could or could not be engaged in those spaces. And then finally, we have the preliminary approval for the House case, which I believe a later panel this afternoon will get into, but really important because it not only addresses back pay for name, image, and likeness, but future payment when it comes to revenue generation from media rights deals and some other things there, roster limits, as I'm sure many of us have been reading up on in the media. But again, this is a chaotic time, and you can really see how college sports has evolved in the last 100 years.
Wow. Okay, and I would like to add to that, I like to refer to her as the godmother of NIL, Senator Skinner. She will be our keynote for lunch, so please stay. She drafted the first NIL state bill, the California's Fair Pay to Play Act, and also the last panel here will go deeper into the House settlement. So if you're interested in that, please stay through the end. Okay. So I would be remiss not to mention the 433 pages of NCAA bylaws that are very complex, and I don't know how any student would be able to navigate through them. And so I believe this issue of the manual was the first time that there's an Article 22 that has 2 pages with respect to name, image, and likeness. So not only are we seeing the NCAA bylaws, but also universities have their own policies. So can you talk a little bit about the NCAA bylaws?
For a long time, in fact, for my entire career, I recognized this font. Never have I completely bought into all the font. That rule book is at least 2 inches thick. Many of you have already seen it. I had a colleague at a major Power 4 school who at one point held that rule book up and said, "Why do we need these, a 2-inch thick rule book?" Well, I caught him afterwards and I said, "Well, with due respect, this is an attempt to protect student athletes' rights." When I was getting drafted, if I could just tell a quick story, when I was getting drafted, my dad called the night before and he says, "Why are you worried, son?" And I said, "Well, Dad, look, all my classmates, they're going where they want to go. They're going to Chicago to work for this firm, or they're going to down to Miami to work for that firm. They picked their location and their boss." And he said, "Don't worry about it. It'll be fine. It'll work out fine. There's something good at every place." And I said, "Dad, what about Cleveland?" And he stopped and he says, "Oh, you got me there." And I got drafted by Cleveland. Anyway, the point I was trying to make to my colleague was this 2-inch rule book is designed to preserve the student athlete's right to pick where they go to school. Professional organizations don't get to do that. You get to pick where you go to school, who your boss is, what community you want to live in. And so much of the thick rule book was to try to find the balance to be able to protect the individual right of the student athlete to select where they want to go and yet play on a level playing field, increase as many opportunities to participate at every sport. We're talking about Ohio State with 36 sports. That rule book has to be pretty darn thick to protect the rights of everyone. It's a really dogged business to get into this, to get into that rule book. And this is the first time that it's been amended where the NCAA is essentially holding up their hands and saying, "We can't do this anymore. We can't figure it out. We can't figure it out for all these sports, men and women, across all the different divisions. It's become too complex." Indeed, that's candidly, this is a side note, I think that's why we're eventually going to federate by sport, and that each sport is going to dictate, just like they do at the Olympic level, each sport will dictate their own rule book. But for the time being, this is the opening that the NCAA is offering to make the transition from amateurism to to some sort of professional relationship. I won't go through the details because if you're sitting here as a lawyer, you don't want to go through any more statutes right now, do you? You're taking your CLE time and you're saying, I don't want, just give me the basics, right? Yeah. So feel free to read through it as you wish, but from our standpoint, it's the opening of the door to this new model that we're going to adopt.
Thank you. Are there any provisions in particular that we should be thinking about here with name, image, and likeness?
Well, everything is so much in flux, but please.
No, you go.
Please. Everything is so much in flux for us as practitioners. We are trying to hold on to the vestiges that the NCAA is asking us to hold on to, vestiges of amateurism, that is. And so we try to run the lines and stay close to them because we want to compete. We try to stay as close to those lines as possible. But I can't particularly identify any particular guideline that we often trip on, but.
And this is just the first snapshot of the first third of the page.
The offers of inducement, for instance, offers and inducements. It's not supposed to be part of the mix. You better believe any intelligent young recruit is going to ask, what are you going to do for my NIL rights? Mm-hmm. And that person deserves the right for an honest answer. So there are so many difficulties to it, and it's going to change again within 6 months. So I'll just be quiet and let the other
No, I'm glad that you pointed that out because I was going to talk about the inducement, or it's not supposed to be used as a recruitment tool or to be used as a substitute for pay for play, but we're already sort of doing that with the NIL collectives. And so if you're not aware of the collectives, and I think that there's going to be a group that's going to talk about them later, we're essentially using the funding that we get from fans, from consumers that are put into a collective, and we're essentially saying, we'll get you this deal from a collective if you come to our school, okay? So it certainly is in reality being used as an inducement, and we know it is because when the school doesn't provide the student athlete with said promised NIL money, they transfer, right? Which they are now allowed to do under the more relaxed transfer rules. So we know that it has been being used, de facto in practicality in that way. And so we also have new legislation that came out in Virginia and Georgia and California as well that says you are allowed to, as the school, directly pay your student athletes their NIL money. And before, the money couldn't go through the school in their sort of relationship between the student and the school. The money couldn't go through that way. But now the California legislation is saying it can, right? You can pay your student athletes, schools directly for their NIL money. So that's directly in competition with this rule. Virginia was the first one to do it. And I was on another panel earlier this week where the panelists said it like this, is they're taking a shot across the bow of the NCAA and sort of wondering, okay, so is my state legislator gonna quote unquote have my back if we do this, right? Because the state is the one that said we're gonna allow you to pay your student athletes NIL money directly. So now the schools are doing it, and they're really hopeful that the state legislatures will support them.
Yeah, indeed, that's not a shot across the bow. That's right into the heart of the boat. and it is a real challenge for us to be able to select. While we may technically have the right to do it under the state law, the association that we're a member of, the NCAA, says you're not. And so we have this conflict of laws that will hopefully get worked out very quickly. We're trying to work around it as well as we can. I see a couple of our members of our collective, and we work in this audience, and I'm appreciative that we can work together to try to honor the things that are important to the university, as well as those opportunities that exist for the student athletes.
And what can institutions do to ensure that this compensation is really about NIL and not pay to play? Because I feel like we're blurring the lines here, right?
Oh, definitely. Yeah. And I don't know that question is even answerable as to what the university can do to be able to clear up that blur. It isn't as easy as anybody's particular philosophy. It's just a strange point in time that we're here in college athletics. So we're trying to maintain the integrity of the NCAA process, but still, again, be competitive. So we have many meetings. In fact, we might have one this afternoon about how to figure out how can we assist the collective in providing compensation for name, image, and likeness opportunities. We meet almost on a weekly basis to try to find different means by which we can get around some of the NCAA rules. I probably said that wrong. Please don't quote me on that.
Good luck. Okay. And finally, let's end with talking a little bit about what this current policy, how it's impacting student athletes.
Yeah, I'll kick us off here. So I think some of the downsides are NIL legislation. As you can see, the NCAA handbook's massive. You should know state law, all these things that athletes need to be educated on, their families, et cetera. So it can cause confusion. Many athletes have testified to Congress that they don't know what they can and can't do. And sometimes they go and ask their NIL directors or their compliance office and they don't even know, right? And that's a problem. And I'll say one of the other negatives is the potential for gender inequities, which we're already seeing. Collectives mainly target male athletes. They mainly target football and men's basketball as well. That looks different regionally. Hot men's ice hockey is popular, baseball, et cetera. So that can lead to some discrepancies between what is offered to athletes and what is not offered to athletes. To my knowledge, Utah is the only institution that has a collective strictly for women's athletes, and it's only their women's gymnastics team, which is a phenomenal program there, right? So if there are these collectives for football and nothing else, that can be problematic and lead to lack of opportunities for our women's athletes. But we're seeing women's athletics grow commercially. Interest is booming. That could potentially change going forward. So that's something I'd consider keeping tabs on. I think obviously the main benefit is expanded economic and financial opportunities, right? That's a clear one. Most athletes across the NCAA are not on full athletics rights, right? So this provides opportunities for them to send money back home if they want to, have more fun, engage socially more. And when they historically could have said no to going out to the movies and to a nice dinner, et cetera, those are great opportunities for them to get outside, pay off student loans, debt, whatever that might look like. Also with the identity development, this is something that I'm really passionate about, and this was mentioned in our first fireside chat with Dwayne and Derrick. Athletes are entrepreneurs and influencers. We've historically seen them as students and athletes. We've historically looked at them as the quote unquote dumb jock. This opportunity allows them to make cross connections on who they are, what they want to be, provide opportunities for them to build a brand for themselves, maybe even start a small business that then they can go and explore when they graduate so that they're not just stuck in that athletics cycle only. I think that's one of the biggest things, and we don't talk about it enough, and we don't shape NIL opportunities to allow athletes to build that brand and use it as a future springboard. And then I will say we're just in this era of athlete empowerment, and it's been a long time coming where athletes have these rights. Very few people sign away their NILs. Athletes historically did, right, through their various documents that they sign when they commit to an institution, into an athletics program. This gives them those rights back, and we in this room as scholars, practitioners, athlete advocates, whatever it might be, we can help them mold and we can encourage them to autonomously do it themselves. We should look at them as athletes from a position of strength, and we have that opportunity through NIL and whatever comes down the pipeline to push them to be better and for us to be better for them.
Any other thoughts on impacts? Larry, have you seen any? Since 2021, was there a shift?
Oh, there's been massive shift since that time, and I would say that I spend most of my time thinking about how to abide by the state statutes and not get sued under those, and at the same time abide by the NCAA regulations and not have an action brought against our school. And so it's, again, I feel, really powerless in many regards. And I have no great advice as to how to go forward. We're just trying to do the right thing as the particular situation arises. I know that sounds like a cop-out, but it's a really odd time in college athletics.
Okay, thank you so much. So let's open it up for questions. Does anyone, okay, I see back here.
University exposed retroactively. I know Reggie Bush is probably going to get his Heisman back in light of the NIL sort of stuff. So, I mean, is Bill Russell's estate going to be saying, you've used our name, image, likeness on your USF website, we would like compensation now? Is it retroactive or just moving forward?
Oh, it's certainly retroactive. If we look at the House settlement, much of the damage claim goes back 10 years of student athletes seeking remuneration for their past name, image, and likeness rights that weren't compensated. So it does react retroactively. Relative to, it's interesting you bring up Bill Russell's rights, and obviously one's right of publicity is post-mortem as well, right? So we had Elvis Presley who famously fought to, his estate famously fought to preserve his rights. So we look at a 50-year window there. Mr. Russell's estate likewise has been very protective of their name, image, and likeness, and the value of Bill's brand. Fortunately, we've got some headway with the estate of Bill Russell, such that we can now put together deals and are currently in the process of putting together deals that have three-way payouts, right? So part to the estate, part to the university, and part to the entity that's putting the deal together. So it's an opportunity for us to partner with those in our past that have great renown and actual market value even today, and we'll look for more ways to partner with them as well. We've got a great. Can I make a plug for a basketball game?
Yes.
So around the NBA All-Star game in February, we're going to be doing a number of Bill Russell things around some of our basketball games. So to the extent you want to see some of those are going to be great. We're still working on the statue, but there's some other things that we're going to roll out at that time.
Fun. Yeah, a lot of states do have post-mortem right of publicity rights, but not all states do. So some states don't have post-mortem rights. And in California, we have strong post-mortem rights 70 years after death. But you do have to take steps to register those rights, whereas you don't for living rights. Okay, more questions. Yes, do you want a mic? Okay, thank you.
Booming voice, but I'll take the mic. Question, it seems like a good portion of this comments we're dealing with the collegiate athlete, but the collegiate athlete starts out as a high school and sometime as a junior high athlete who's been recognized and builds a following going forward. Will this panel or will these conversations today speak to that as well? Because again, from my own experience in dealing with student athletes, they start early. That's when their skills are recognized, particularly if you're talking Olympian where they're in their teens. So I got a ton more stuff, but I'll stop with there.
Indeed, California is very liberal in recognizing the right of high school athletes as well, and so I have yet to see in California a student athlete that is precluded from entering the ranks of college athletics by virtue of their previous monetization of their rights, and so while one may be able to argue that they wouldn't be eligible. That hasn't been the practical reality. They've been eligible at every step. I worry that it's hard enough to teach 18 to 24-year-olds how to manage their money. Look, I'm a father of 5. I remember those teenage years. They couldn't handle a $20 bill and a tank of gas, right? So I think that's really going to be a challenge for a lot of our high schools that often produce high-end athletics. And so I don't have any great advice for you, but I haven't seen anybody be precluded from participating in college right yet based on their monetization. Go, please.
It was really more about, it was really more about, you brought a case where the schools themselves have certain deals, let's say beverage deals, and they're trying to figure out how to make it win-win. However, let's say this is a high school athlete that has Gatorade, and the school has opposite of Gatorade. And so there's a conflict going in because the athlete may be good for their team on a range of opportunities, but that deal that that high school athlete has goes on, and it's a multi-year deal that may be against what the school has in a different beverage company. I know that I hate going to Levi Stadium because they have Pepsi as a pouring right, and you cannot make a Long Island with Pepsi.
Indeed. Indeed, those issues that have already arisen, and we've been able to work through them. They typically arise by virtue of associations with shoe manufacturers, right? So you've got your Adidas and your Nikes and such. And so we have a number of student athletes that play for us that are coming in with deals. And the realities of our situation are that we have to insist that that athlete can keep their deal, not a problem, but in terms of any official event, they have to wear our gear. And so far, it's worked out fine. Each of the shoe companies has been accommodating, so as not to restrict the student athlete from going to a particular school. Oh, you can only go to an Adidas school, or you can only go to a Nike school. Most of the shoe companies, in fact, all the shoe companies have been very accommodating of that. And the deals that the individual has have been adjusted to note that. Fair enough? I've seen them work well together.
Okay, last question.
Real quick, I'm Kaba Matuo here at USF. How do you think NIL rights will be affected if student athletes are determined to be employees?
I think we need the professorial view on this one.
Wow, I could have answered the amateur, which we do now, right, question, but this one is tough, right? So what do we do if student athletes are considered employees? So I want to make sure we understand why that question is even on the table to begin with. And a part of the reason why we really want student athletes to be able to bargain collectively is because of the value of their broadcasting NILs, their BNILs. And when we talk about things like revenue generating sports, like D1 men's football and men's basketball, they are revenue generating because of the value of those BNILs. And if you are on a basketball team, for example, you might not be the individual star player that will have these multi-million-dollar endorsement deals, but the value of your collective NIL has a lot of value because they have to sell that to the TV broadcasters and to the EA Sports now. Again, we have that back, right? So whether or that's where the money is, because most of these smaller NIL deals, and I've looked at like the empirical numbers on I've tried to. There's not a lot of information because we don't have like clear disclosure rules for everyone. They're not worth that much money, right? We might have a student athlete getting $100 a month to promote a burrito brand on their social media to post that, once a week, right? So the money really is in their BNILs, their virtual NILs, and to be able to access that money fairly, they need to be put into a position to collectively bargain for those rights. That's the argument. It's easier to do that when you are a professional athlete, like in the NFL, because there's literally just fewer of you. Okay, your collective interests are more aligned, even though you have players that are quote unquote better more athletically, have more athletic exceptionalism than the rest of the people on the team, right? But there's fewer of them, and that just doesn't exist in college sports. They're just very, very varied, and their interests are very varied, and why they're there, participating in a revenue-generating sport, for example, versus one that's not a revenue-generating sport, and their motivation for being at that school, and the school's expectations of them for participating in athletics. And I know we talk a lot about how we're losing some of the primacy of education with all the move and towards promoting student athlete NIL, but I just want to point out that was a problem that existed to begin with. And you have to sort of be aware that different student athletes' motivations for attending different schools to get a particular outcome is not always an educational outcome, okay? So I just want to take the time to say that. But in terms of so how do we let them collectively bargain? Well, one way to do that is we call them employees, okay? Because employees have rights to collectively bargain for things like that. But if you call them employees, then wow, there's a whole host of other problems that are going to arise because now you're an employee. Now I can tell you when you can show up, and now I can tell you, I have a lot more control over your behavior, for example. How's that going to play out with the transfer rules? Maybe I've got to stay and play on my women's soccer team, even though I'm really unhappy here, right? Because I signed this deal, this employment contract saying that I would. So there's a whole host of other issues that come up if we call them employees, just because we want to give them their rights to collectively bargain. That was a lot, sorry.
That was great.
Okay. If I could just append,
Yeah.
and the collective bargaining is so important in this case because the NCAA, collective universities, need rules by which they can create competitive opportunities and create value. So there's this balance that we're teetering back and forth on. The antitrust exemption that you get through a CBA is what has made the NFLPA, the NBAPA, the MLBPA, and it's made each of those organizations very stable. Without it, we're really unstable, and we have so many elements of that relationship between the student athlete and the university that still need to be worked through. It would be awesome if we could figure out how to create appropriate unions, appropriate representations within those unions. But the other challenge is getting the universities to work together. The SEC doesn't want to work with the likes of the MAC schools. And so there are so many hurdles to getting to a point where we could really honestly say there's a collective bargaining agreement that would give antitrust exemption that would defend against all the different lawsuits that the very brilliant lawyers are bringing daily against the schools and the NCAA. So good question, bad answer.
Okay, we're out of time. Thank you so much, panelists, for being here.
Good morning. Thank you, everyone who is present here or on Zoom today. We really appreciate the attendance and the turnout. My name is Stephanie Cohen, and I will be moderating today's panel on negotiations and protecting NIL rights for student athletes. I'm currently a second year here at the University of San Francisco School of Law, and I am the co-vice president of the Sports Entertainment Law Association. I am also a student clinician here at USF, where I work under the Internet and IP Justice Clinic, where I am a temporary agent under the USPTO, and I work with pro bono clients and matters on patent and trademark prosecution. So before we get started today, I want to introduce the panel and give them an opportunity to talk a little bit about themselves, about why they're here, maybe a little bit about NIL and their career thus far. So I'll hand it off to Wayne.
Great. So my name is Wayne Stacy. I'm with Berkeley Law, Executive Director for the Center of Law and Technology. Part of my portfolio includes all of the IP issues, which covers all of our sports programs. So I'm not an academic by career come to this in the last few years. I spent most of my life at Cooley doing IP litigation and IP licensing. Then after 22 years in there, somewhere you lose all personality if you do patent litigation for too long. So I quit before I lost all my personality. Put the rest of my career into public service. I was the director for the West Coast of the USPTO for a short time. And then I got the opportunity to go to Berkeley Law. And what makes me relevant for this conference, lead the NIL clinic there, which was set up with an exclusive focus on athletes kind of at that level statewide, all Cal, all Cal, I guess all of Cal, and then all of the University of California schools, begrudgingly UCLA, and all of the Cal State schools. So we try to help athletes that are below the line of where they can get lawyers, where they can afford agents, and where they really get attention. So, thank you.
Thank you. Hi, everybody. I'm Joe Soberone. I am a fifth-year college baseball player and second-year law student. My passion is the right of publicity. This is the area of law that I am pursuing, and I'm writing on the issue in pursuit of an IP certificate. I plan to join the clinic with Professor Pfeiffer next year. And yeah, these issues are my life. I mean, I'm not, I'm no NIL star, but I have had my opportunities to, write my own deals and work with some companies. So I'm excited to contribute to this conversation.
Hi, my name is Matt Quinlan. I'm a 2004 USF School of Law graduate, full-time practitioner here in San Francisco. I have a personal injury and fire claim litigation firm in the Marina. I'm also one of the founders of the Hilltop Club, which is USF's NIL collective. I'm a volunteer in that capacity and a contributor to it, and also now responsible for overseeing the organization and its interaction with USF. And I have also become somewhat of a de facto general manager for the men's basketball team. And so I'm very closely tied into the team, the school, the athletic department, the players and the families. So I think I have a unique perspective here on this NIL thing. Given how close I am to it and how I've watched it evolve and grow from 3 years ago when it was just kind of an idea to now, which is, it's a proper business and industry. So I look forward to sharing my perspective.
Hello. Okay, I'll use mine. Thank you. That's it. Hi, everyone. My name is Mariah Cooks. I am not a USF alum, but I feel like it. I am so honored to be here with you all today. I'm a former student athlete. I played basketball at Washington State University pre-NIL. So it's an honor now to be able to, in my capacity as an attorney, be able to advise and consult student athletes through this new world of NIL. And my background, I started my career as a prosecutor in Alameda County as a district attorney, and then transitioned to a firm here in San Francisco, Murphy, Pearson, Bradley, and Feeney, where I co-chair our sports and entertainment department there. And essentially the way that our practice is set up is, whatever legal need or issue our clients have. We have clients in the WNBA, NBA, NFL, hockey, you name it, we've touched it or dealt with it, are able to advise universities as well, compliance offices, specifically with regards to NIL, but also just other kind of crisis management, high-risk issues. But whatever legal need you have, we are able to cover for the most part. And if not, we have a great network that we're able to, be a part of that covering and connect you and fill those gaps. So super honored to be here with you all today, specifically related to name, image, likeness. I'm also an NFL agent, and I got into that work through my brother. I was advising him when he was a college football player. He's now in the NFL, where he's my client too, which is pretty cool. I have other clients as well, and so he is really what initially introduced me to name, image, likeness, and because he was, part of that first wave of it. So yeah, like I said, very honored to be here with you all today.
All right, thank you panelists for being here. We really appreciate it. I'm gonna dive into protection first, but we know that the landscape of NIL has shifted dramatically since 2001 to 2021, providing new opportunities for student athletes to capitalize on their personal brands. With these opportunities, we know comes a lot of risks, especially when it comes to larger brands. So to begin, I want to dive into what are the first steps that student athletes should take to begin their journey in the NIL deals, and how can current student athletes protect themselves during negotiations, particularly when it comes to larger brands?
I'll start. So I would say first things first. The way that how I encourage my student athletes that I work with is, you're your own CEO. And so each athlete is, you're building a brand that's bigger than your sport. They're able to have creative autonomy over not just their time as a student athlete, but like their future selves. And so I think it's really important to like know your value, understand the market for your sport. And that's just good for an athlete, whether you're, a high profile athlete or not. It's just good to know so that when these opportunities do come to you, you're aware of your value and, seek legal counsel. I say like, don't sign anything. It's so easy now. You literally just like, student athletes just like press buttons, like 3 buttons, and then you got yourself an NIL deal. And so it's so easy that, and all they see really is like, oh, what do I get out of this? But not necessarily, okay, what's required? What's the term of this contract? Is this an exclusive contract, which means that I can't, if I partner with this brand, then I can't work with any competing brands that are within the same industry. And so there are certain terms too that you can, and we'll get into that a little later, that are negotiable. And so I think too, for the athlete to know like the power that they have and like they really are the asset. And so if, and you don't have to say yes to every deal that comes your way, I really encourage my clients to be intentional about the partnerships that you accept, the NIL deals that you accept, and make sure that it aligns with your values and not just, where you see yourself now, but your future self. I say, if I'm working with an athlete in California where, and I'll use cannabis as an example, where cannabis is like, very common here. People shouldn't, but they do, just like smoke it on the streets. But then, but if they have dreams to go then and play professionally, or, let's say they transfer something or they get a job down south, they're about 20 years behind. And so where something is so as common as cannabis and getting, you can get a deal here, that could prevent you from getting a job or taint your brand for your future self. And so that's just a small example, but like just the mindfulness of not just where you're at now, but also where you're going to be in the future.
I agree with all that. I mean, those are good points. I think, obviously, I think someone, your question, I think, was, how do you go about finding them or whatever? Oftentimes, I think they will find you. So you're not necessarily going to be ready for that. Young kids that are 15, 16 years old start to have these things find them. So you may not have had an opportunity to put a team around you and have thought about these things. And so, that's the only point I would make. There's a difference, obviously, between, a college student seeking opportunities, because it's kind of doing it on his or her terms, but oftentimes when you're quite young, you're going to have opportunities come find you. And so those are kind of the ones I think that are a little more risky. Yeah. So you find counsel or at least someone you trust and respect, and get some advice and just make slow decisions.
So the one piece I would add here is that when you look at the majority of deals across the nation, they're not big enough to justify lawyers. They're not big enough to justify agents. So these are kids being left out on their own with no representation, no guidance. Most universities are going to refuse to provide legal guidance. They just can't. So what happens with these students that are signing a $1,000 deal? No lawyer is going to pick them up. And those are the deals that there's going to be, well, there already is backlash on, but they're giving up huge rights, and it's not making the paper yet because they're not turning into the next star. But they're giving up huge rights, and I don't think because people are sinister, but because often the people on the other side are not using lawyers either. It's a local pizza shop. Car dealers, I'm always suspicious of. They can afford the lawyers. But what we've seen is there's agreements come through that are written by lay people. They make perfect sense, and then they have no termination date. So the rights are there in perpetuity. Probably not going to want to use them in perpetuity until somebody hits it to the big time. So I worry about that group, and I think the colleges, universities can't do a lot directly. The NIL directors they have can steer a little bit, but the NCAA hasn't really put out great forms, hasn't put out great guidance. The conferences, I've been disappointed. They haven't put out guidance, templates, training for families. And that's what I've been doing a lot with my centers. We're putting together a video series really for families because I'm not sure the student athletes care until that first deal pops up. And then by the time they've signed it already. It's my favorite when they show up. I just signed this. Can you tell me what it is? Thanks. But I hope that when you think about this, and for those of you who are in the space, give just a little bit of time to the athlete that's rising up the ranks, but it's doing the $1,000, $2,000 deal, but can't afford a $500, $750 an hour lawyer, or the agents that they pick up are sketchy. That's been a real problem.
Sorry, really quick. Also, USF is blessed because it has a law school attached to it. So, if I was a student athlete at USF and I got, like you said, kind of a smaller NIL deal, but still needed some sort of legal, you still need some other legal eyes or a covering, someone to look over this, kind of show you what you're signing up for before, or maybe gaps that you're missing through your lens. And so talk to a professor, build relationships with, law students. And not giving you legal advice, let's be clear. But, like I said, just having some form of way to protect yourself, if you aren't having these big deals where you have an agent or an attorney necessarily, like I say, build relationships with the professors, with the law students who are, really diving in, because it's contract, they got to be able to review a contract. And so you can find a lot of people here who can do that.
Yeah, even going further to that, I know, Joe, you have personal experience. Do you want to maybe touch on a little bit of your personal experience on understanding NIL rights while you were either in San Diego or even here?
Absolutely, yeah. And San Diego is where it started for me. I was there in 2021 when everything kicked in. And we had a seminar. It was 2 hours long with our whole athletic department. And I think half of us fell asleep during it. It was a lot of information that not a lot of us retained. And it was awesome that UCSD put that out and tried to, notify us of our rights and how we can take care of ourselves. But it didn't stick for a lot of guys. And I know even for myself, I'll be honest, I am not Paul Skeens. I am not Bronny James. My deals were very small, and they were cool because I got free food. You know what I mean? So in undergrad, that was big for me. I worked and did some promotional videos for this meal prep company, and they would send me 10 meals a week, and I would just put them on my story, and I would get fed vegetables, full square meal. I enjoyed it, and the truth is, though, I put myself at risk. I didn't read it. I was too excited to get a shipment of meals every week. I signed my name and posted a video every other week, and I put myself at risk, no doubt. Nothing's come of issue so far. but I definitely should go back and look at those. Maybe not, who knows? Now, where I am now, having had some experience here at USF Law and being around great people in the law, I actually have a company that reached out to me last week. They sell hats, and interestingly enough, it's a very similar click on 3 buttons type NIL deal. And I was looking at the final contract, and the effective date was in 2022, and haven't signed it yet. So, there's stuff that would have fallen through the cracks for the average student athlete, but I caught it, and probably shoot him an email back and say maybe we should fix that. But yeah.
Well, thank you. That's very insightful of your experience. I know Mariah touched a little bit about contracts, and I want to point out that the NCAA bylaws that just were ratified in this past August, or this August, talk about education. Specifically, they quote that the NCAA National Office shall make available comprehensive education regarding NIL activities in a manner approved by the Board of Directors. And this education must include provision of standardized contract terms for the use in NIL agreements. So I want to ask you all what the standardized contract terms the most student athletes should be aware of, and it's ambiguous a little bit. So what should the standardized contract terms be in accordance with the NCAA bylaws?
I would say for that, the standard, there's going to be a term, start and end date. Like I said, they can still include that exclusivity term, but that's negotiable. There's going to be terms as to what your expectations are as the one receiving the benefit or performing the services. See what those requirements are for you. And then how to, I always look at, if I look at worst case scenario, if things go bad, what does this look like? If I want to end this relationship, this contractual relationship, what contract terms and provisions are in there to kind of let me get out. Some contracts will have indemnification terms, which you need to be mindful of, would say like if you're the ones who breached the contract or a third party is injured based off your actions, you are required to indemnify, so defend and hold harmless the company in which you're contracting with. And so that's really like on one-sided, like that's like going to be more of a one-sided contract where it protects the company and not the student athlete. And that is where I think it's important to be able to really negotiate that type of situation. What else? I would say in terms of being in compliance with the NCAA, it's always important, make sure that you have a good relationship with your compliance department because, you may be in compliance with NCAA, but not in compliance with your university. And so that's something that you want to be mindful of as well.
And I could say I've got a short checklist for our clinic. When one of these two things comes up, you have to call me. There's just no discretion about it. The first, international students on a visa. For those of you that don't know, this is a horror that's just beginning to fully arise. Don't know how it's going to come up next with the new administration and how immigration is going to be there. But you take NIL money, you're no longer working on here on a student visa. So for a place like Cal with so many international student athletes of NIL caliber, this is a huge issue. And some schools are, I haven't said that correctly, some schools are advising, press the boundaries. I think LSU's got a problem right now with a basketball player that's stuck outside the United States. So that's career ending, that's life changing for a student if you get them barred from reentry into the United States. So if you ever see that, that's number one. You have to flag that. And I think you have to be conservative about the advice. And especially in these little $50, $100 meal type click-throughs, going to get barred from reentry to the United States because you got 10 free meals. Yeah. And I'd seen those things. Those are the ones that come to me where somebody's already signed. And the officers are going to figure it out because all it is on your social media profile. You can't hide it. So I think, if you look at that first, and the second thing I have students, any agreement any agreement that does not have a fixed termination date for use of IP, period. It's flagged right then because either the agreement is sinister or incompetent. There is no other way to talk about that. There is no right that anybody should be giving that's perpetual use of my IP until I'm dead, or until I'm dead plus 70 years and out here. So you have to look for those. So if you're just scanning an agreement quickly, and if you see no termination date, it's either not in there at all or it looks really far in the future. If it's really far in the future, they're easy to spot. But these sloppy agreements that don't have a termination clause in there at all slip through. And so a student that's actually being careful about reading them, what we've seen is they look at the provisions that are there, but they don't notice the provisions that are not there. And that's the biggest danger of what I've seen out of those. And from there, we can edit them out. And what we found is most companies will add those back in, or they never put them in any agreement, and they want to be good, they want to be decent to students. So, I use our role as the University of California then to say, hey, maybe consider this that's more fair to students. And so I've never had anybody push back and say no. Everybody's put it in so far. So I'm hoping that most people are good about that.
Where I would add exclusivity also is probably a pretty hot button issue in a contract. You can sign a non-exclusive agreement, which is obviously much more friendly to the student athlete. I write contracts, or I'm a party to a contract on behalf of the collective, not the student. So I'm on a different side of it than these guys are. But we, because our intentions are good, and we want to write favorable contracts for our student athletes because we want them to appreciate the contract and value the contract, not be bound in some negative way by it. So we write loose terms, and everything's, non-exclusive. We're very clear about termination dates. We're very clear about what the expectations are in terms of performance. We're very clear about what the consequences are for breach of both parties. So those are kind of some of the things that I think about when we're putting something together. But again, I'm not writing a contract like I would in my private practice, which is, I'm more zealous in that way. I'm trying to write a friendly, soft contract for these guys because we're partners and we want them to feel good about the deal.
Thank you all. That's very insightful on contract law, if you don't know anything about contracts. I want to move now towards a little bit of core values. I mean, we obviously talked about lawyers, which we have 3 of up here and 1 incoming. But it's important for adequate legal counsel at these NIL deals and ensuring student athletes make these informed decisions. So I want to know, what are the key factors that student athletes should consider when engaging with, or even considering just to engage with, legal advisors during these negotiations?
I think anytime somebody signs a large contract, like Wayne mentioned, some of them are going to warrant hiring an attorney, but maybe you have a friend or a competent family member that would be happy to look at it as with experienced eyes. But certainly, if you're going to sign a big contract for your NIL rights, I think you certainly should get some counsel on it. I would say most do. We have contracts with the men's basketball players, and nearly every one of them either has an agent or an involved family member or some adult that's advising them. And I'm always happy to see that, given that we want their best interests. So certainly a big NIL deal, always get representation as you would if you did any big deal in your life. Buy a house, do a deal, buy something expensive. I mean, you don't want to be signing something unless you understand what you're signing.
The fun piece about that is what's a big deal to me after a life in Silicon Valley versus what's a big deal to an 18-year-old is wildly different. And so we've had people say, well, I should go get a lawyer. It's a $1,000 deal. So how much do you think a lawyer is going to cost an hour? Like, well, what'd you charge? I'm like, I was a little under $1,600 an hour and I retired. So you get about 12 minutes of time. So no, but if you find the bargain basement lawyer, in Omaha, Nebraska, it's still going to be $250, $300 an hour. And that kind of realization, then I figured out it scares them so completely far away, they never want to talk to any lawyer again, even free ones. So I don't know how to, I guess my thought is we need to make sure that you know who you're talking to and you're right-sizing a deal. Your point is, it strikes me as this most excited student I have that came in was with free food. Yeah. I mean, maybe a net value of, I don't know, over the year, $2,000, but just you could have been a brand new car. It was just magnificent to watch, but no lawyer, no agent was going to touch that deal. So.
Go ahead.
I think this area is where the NCAA can step in and mandate that these schools provide representation for their athletes to make sure these third parties are not, exploiting their students. I think the value that athletes convey to their campuses, to their universities, it's worth it for them. I think it's important that universities and the NCAA put the rights of their athletes in the forefront. I think, firms everywhere would probably like to be a part of that framework where athletes can just come to them, paid for by the NCAA, and paid for by athletes with the labor that they contribute to the league.
Or the school, right? And I think we're probably headed that way. In years past, there's been such a separation between the schools and the deals, or the schools and the collectives, and those things are coming together quickly. And we're kind of on the doorstep now of a whole new regime on this stuff. And I think one of them is going to be the student athletes at these schools are going to have an opportunity to get, professional eyes on the deals they do, and it'll protect them a lot. So to your point.
Yeah. And I think too, just like practical tips on selecting, and if you are going to have an attorney or counsel, you want someone who has experience in the sports industry, understands, and it's nice to really even understand your sport specifically. That's really nice. Understands the NCAA regulations. Also, see what their fee structure is. That's important. Some people we are able to provide because we understand the hourly rate. No athlete can, they may, some athletes can afford, $600 up per hour, but most can't. So, we've kind of created this package that we are able to present different tiers of services to our student athlete clients, and see what the communication style is of that attorney. How are they going to communicate with you, your family, and I think of most importance is you want to make sure that you feel comfortable with them. This is someone that you're trusting to be a part of your covering. And so if you can build that trust and have that connection, because when I tell my clients all the time, do not ever not call me because you're afraid of a bill. I don't charge, especially student athletes, for anything that comes to mind. If something comes up, I need to be your first call. I'm not going to send you a bill for that. It's really the substantive work that is really what's included in our package. But the communication back and forth, I want that, because what's cool is I'm seeing the athletes that I've been working with for a long time, they'll send me contracts and be like, hey, I've noticed X, Y, and Z. They have this this exclusivity term, but I think that we can negotiate out of it. They're telling me the strategy, and did I miss anything? And then, so it's really cool to watch them really develop, like I said, as CEOs of their own brands.
I think just generally about this whole topic is NIL over the last 3 years has got this kind of negative cloud over it, because everyone expects something bad to happen or somebody to be taken advantage of. And while there may be a few instances of that generally, and on the whole, that is not going on here. And, we talk about worst case scenarios and kids getting taken advantage of and signing bad contracts and nightmare scenarios. But, that's 1 in 100,000 or something. There's lots of good opportunities out there. And so me personally, it's been part of my mission to kind of change the narrative around NIL and how everybody views it. And so I'm a little sensitive to the desire to take it to a negative place when there's so much positivity going on too. So I just want to point that out. There is a need for a lawyer on some jobs, but you don't need legal counsel on every single thing you do if you're aware and competent in and of yourself. So I just want to add that just so it doesn't get going in a too negative of a direction.
Well, I'd like to add to that. Working across multiple schools and multiple sports, I've seen something interesting that a lot of the companies engaging in NIL at the collegiate level are frequent flyers. They're not just working with one athlete, they're working with 20, or they're reaching out to 20 schools across the state or 10 across a region. And what happens a lot of times is somebody will flag that, say, hey, what do you think of this form that's coming in? It's not my client, it's this company on the outside. I'm like, here are the 4 problems with that agreement. You just need to level it here. And every time it's gone back, it's been fixed without it's not even fixed, it's really updated and made into a better agreement. So there's really an opportunity to work with those frequent flyers, and once they get their forms built to a better spot, it'll protect all the athletes. And if you happen to do it at one school, it's really gonna drift through all the schools. But I have not actually seen any purposefully sinister conduct at all trying to take advantage. It's just going to be accidental, and then the company gets sold off that had those rights, and now all of a sudden you're dealing with somebody that you never knew.
I think on that, am I taking this too long here?
Go ahead.
All right. I think that boils down to what NIL is, and that's publicity and endorsement. I don't think any of these companies want bad publicity by messing up a contract with a student athlete. I think that's why you're seeing these quick fixes, and you're saying it is a very positive sphere, and people are being compensated for what they deserve. So it's good to see it in a good light.
Thank you, Joe. I want to shift a little bit. Joe, you did talk about a third party and representation from the institutions, and I think Matt is going to have a lot to say, but we're going to talk about NIL collectives a little bit. I know obviously they emerged a little bit more after legislation passed in July of 2021 that student athletes now can compensate off of their NIL rights. But I want to know a little bit more, maybe Matt, you can explain what an NIL collective is, but how do these collectives compare to individual deals in terms of negotiation power? And what negotiation tactics should athletes consider when they work with an NIL collective?
So an NIL collective is a group of fans and community members and boosters that want their preferred athletic team to perform well. And in this environment, student athletes now know that they can earn money through their participation at various places. And so it's become a very key, perhaps the most important element to choosing a university to attend. And so collectives came together so that they could guarantee these student athletes who are assessing all these different opportunities around the country, they could guarantee them an opportunity to earn money. And it wasn't like, well, just trust us, we'll do our very best when you get here. That's not good enough. And so collectives, around each university came together and were formed. And it was basically all the people that really wanted to see the team do well and people that were willing to kind of put their money and their businesses behind that idea of the team doing well. And they understood that if there is no market yet for the NIL of these individual athletes, let's create one. And that's what NIL collectives do. They create one. So, another negative buzzword around NILs is pay-to-play thing. That gets people all riled up. And in some ways, it's always been pay-to-play. Why are we giving these kids scholarships? Because we want them to come. Why are we giving them stipends? Other kids aren't getting those. Why are we giving them per diems? It's always been pay-to-play. And so that's got a negative spin on it, too. And so, we want to be able to bring these student athletes in here, allow them to monetize themselves. We're willing to put up our personal money and the companies that we're associated with money to create a marketplace for these kids so that our basketball team at USF can thrive, because we know that if our basketball team thrives at USF, the whole university thrives. And so you've seen a warming of universities to NIL collectives, because I think it's now understood that there's nothing in it for me. I'm a volunteer. I don't make any money through this. I give my money and my time and expertise to this process. All I want is good for the university. All I want is for the basketball team to do well and allow the community and the alums and the fans to realize the benefits that are going to flow from that. So that's the spirit of a collective. Another thing is these collectives have got a negative reputation in some kind of way, which is so undeserving. Right? Most people involved in collectives care the most about how our program does and how our school does, and care the most about the student athletes and want to give them money and create opportunities and donate our time and our networks to these kids because we care about them. So it's kind of a shame also that the collectives have developed a negative reputation. That's, something that I'm happy to, push back on and have taken that as a serious part of my responsibilities here at USF. So I do think collectives are misunderstood. I do think contracts with collectives are much more friendly than contracts with outside organizations. We have non-exclusive deals with all the guys and gals that we have contracts with. And so on occasion, they do have outside NIL agents that develop NIL opportunities for them outside of the things that we create. And those are things I'd be a little more cautious about if I was a student athlete, because now that's kind of like you're out of the safe waters at that point of the people that care about you, and now you're into a cutthroat business world, and so it may be a little bit different there.
So I'm going to push back, Matt. I think I would, because I've had the chance to see several agreements outside of the state of California. So it's not Berkeley, it's nowhere in the Cal system, but there are, I think, two types of collectives. I'm not so sure that the collective at a University of Texas or University of Michigan is monetizing NIL rights. That is a true pay for play. So I think there are different incentives along the way. I mean, Michigan's going to route $10 million to the next quarterback, and they're not going to get $10 million in value. But in terms of the legal piece of this, the thing that's disturbed me, and I use it as an ethical test for students to figure out how to do this, is several of the collectives, I'll just leave it at several of the collectives, started preparing for audits. With the NCAA was going to say, was looking to see any agreement over $600 and make sure it was fair market value. Well, how does it look like fair market value? The NCAA is not going to have a lot of opportunity. So we're going to put in clauses that say you have to do 15 postings a month and 5 live events per month. No student's going to do that. And that's going to come with don't worry about this. We're just making this look like a lot of work so the NCAA doesn't know the real value. You get your money whether we ask you to do those or not. That kind of situation, I think, makes everybody look bad, and it makes the people that are doing it for true NIL look bad. But as a lawyer, can you look at your client and say, hey, this agreement, I know it's in your favor now, but you just signed up for 4 years and about 700-800 hours of work. But they say you don't have to do it, but if you choose not to do it, then you're in breach. You've got to return all of your funds that you've received so far.
Yeah, I get you. I mean, that sounds like a bad deal. We don't have that kind of responsibility.
That's why I say there are two types of collectives out there.
I would also make a distinction that, pay for play, I think is a bad way of attacking this whole arena. Overpaid for their NIL rights is, I think, a more fair way of saying it, right? So I'm open to that. Perhaps there's overpayment going on here because of the competitive nature of all the people that are behind it. Fine. But pay to play, it's always been pay to play.
I'm going to move on just because this is kind of part of the debate we're having right now. But I know that a lot of, in NIL collectives, they are allowed to give money towards the sport that, that they're getting endorsed for. They give the money to whatever sport is going to benefit them the most. And I think that puts a lot of risks to other sports, specifically women's sports, or not the big three, not basketball, not football. And I'm sorry, Matt, I'm going against the collective here, but I want to know how do NIL collectives impact the opportunities for athletes in these lesser known sports and the risks that they pose in terms of neglecting or even eliminating these women's programs or just lesser known programs?
I mean, I do think that's a sensitive topic. I want to be careful also with what I say on this, of course, because I don't want to say the wrong thing or give the wrong impression. But there's different markets for different sports, and they benefit the universities in different ways and with more and less magnitude. It has nothing to do with the sex of the athlete. It has to do with the interest in the particular sport, no matter who's on the field or the court or whatever. So, football and men's basketball, and to a lesser extent women's basketball, are the areas where there's the most interest, the most money that comes to the university through those avenues, and so I think they get more attention. It's also that happens to be the sports that bond alumni and fans to the university, and so those are the ones they're motivated to give to because they want to see, the football team, let's say, win games is more important to them than the lacrosse team or the wrestling team and so forth. So, yeah, I do think, depending on what sports you're in, you're going to get more attention. I guess that goes for all things in life, coming up. If you're a hotshot ping pong player, you're not going to get the love of the hotshot tennis player, and it's just a fact of life. So, that being said, we are sensitive at the Hilltop Club for, making sure we don't behave in some sexist way. And we do have contracts and with the women's basketball team as well, and relationships with them, and develop opportunities for them, and have donors that come to us and want to give to the women. And that's where that money goes. So we do it both ways, but for sure there's, kind of different levels to it.
Okay. We have about 10 minutes left, but before we get into questions, I think I want to end off with maybe just the impact that student athletes have, or the impact NIL has on performance and academic-wise for student athletes. And I guess this can go for everyone, but what do you believe student athletes miss out on if they don't fully understand their NIL rights, and how might a better understanding influence their career trajectory?
So I would say, in kind of on the same vein of where, we're talking about women's sports, and for women's basketball, for example, there's been a huge influx of interest, of viewership, of a demand from the public. And I don't think that it's a coincidence that this rise has coincided with NIL. And, because now you have these fans who are from all over the world who are looking at their social media. They're seeing them now on commercials. There's this recognition now. So now I'm not just invested in you, in whatever you're promoting, but now I'm watching these games, and there's more viewership. There's more of a demand because I feel this connection with you, and this is happening across all sports. You're going to see a ripple effect, and I don't think that this this rise, people are like, is the women's basketball phenomenon going to fall? Or I don't think so. I do not see a world where that happens, because there is just such an increase in demand, and the brand is bigger than the sport. And I think that is what is really important. And we've seen, as a student athlete myself, I knew what I wanted to do post-sport. But of a lot of athletes, they've invested so much time and sacrifice and dedication to their sport that they have a hard time seeing themselves without it. But if you're, as a high school student athlete, if you're starting to see yourself, like, what are my interests? What type of things do I like? And you're starting to build yourself bigger than your sport. That transition, because everyone has an expiration date, especially when it comes to sports, that transition's not going to be as difficult. So not only are you missing out on like monetary opportunities or products that you may want or need? But just in life, the transition out of sport is going to be much smoother, and you're going to be developing this skill set that once you do hit the workforce or whatever force, you have entrepreneurial skills and all these other skills that you've been developing throughout your time as a student athlete.
I'll just add on to that, given that I'm, around these young people a lot, have relationships with them. It's pretty amazing to me how developed and mature they are. I think of myself when I was 20, 21, 22 years old. And it was different than how these men and women are. And in part, it's because they're forced to grow up to go through these things. But also in part, it's because they have interaction with the adult world in a way that when I was a college student, I didn't have. And so it's prepared them to kind of take the next step. And so I think it's a benefit personally for the student athletes, for sure, to be able to engage in NIL opportunities.
And I love what you had to say, because there's a category of NIL people don't talk about, and that's the job-based NIL. I mean, now students can work. My alma mater pioneered all of the violations. I came from SMU. I think it was mentioned earlier. I was there in the time we had a wonderful NIL policy before it was legal. Championship team and 30 years of penalties for it. But part of it, again, we played football with OU and OSU, Barry Switzer. We had plenty of cheaters around. But they pioneered the no-show job, and those were fantastic. Car dealers loved that. Here's $100,000. You need to come to work on Tuesday, any point in your life. Just come here on Tuesday. Here's $100,000. But now students can actually get real jobs. And the NCAA went so far that students couldn't actually do anything useful. And I've seen so many students come through doing, getting $500 to do birthday parties and then meeting somebody for an internship or something like that. And that kind of gets wrapped up in the $10 million quarterback contracts. And there's so many good pieces in that part of the world for enlarging those opportunities, as long as students know about them and as long as schools really reach out to make those connections and say, hey, I'm going to support our pole vaulting team. And we're going to connect people on that. I'm still looking for pole vault fans, but the coaches, the athletic departments have to get involved, because the students can't generate that market themselves, and it's just not going to pop up.
All right. Well, I think we have a couple of minutes left for questions. So if anybody on the floor has a question, I am more than welcome to hand my microphone over.
Hi. My question is about, you kind of talked about it a little bit, navigating or determining the fair market value for student athletes. It's kind of different for each state. Let's say you get a player that gets offered a certain amount from a collective in San Francisco versus, let's say, in Idaho, right, at Boise State. How do you advise or negotiate a fair market value for that athlete?
Yeah, well, I think first off, the internet is amazing, what you can find in, and so I do, obviously as counsel, do my due diligence, but I encourage the athlete themselves to do their due diligence as well. And then we have conversations about it, because first, what is the ask? So what are you being asked to do, and then what is the compensation, whether that's monetarily or product-based? What are you being asked to do? What are you going to receive? And then kind of look around, because it is different. If I'm a gymnast, I'm wanting to go to LSU because there is a huge investment from, we talk about the market, and and their collective there is in huge support of their gymnastics program. So there's a lot of money that goes to that program, and a lot of relationships in that market for a gymnast. But that's not the same everywhere. And so I think it's important for you to recognize the market that you're in physically, and kind of go through that area. But then also, but also look at what the possibilities are and kind of find where that happy medium is. And then just as an individual, what you're, if you're the star of your program, even if this, it's not a huge market for women's basketball, like Matt said, these collectives, the community wants to see programs thrive and do well. So if you're that player, then you're going to have more bargaining power in terms of what what your value is, because you are kind of that beacon of hope for the program that's going to really lift everything up around you. So that's kind of what
I would just add from a collective perspective, I mean, the market is pretty, I suspect, pretty inefficient and certainly opaque. It's hard to know. You rely on your relationships. This is my role. You rely on your relationships to get information, to understand the market. It's evolving so fast. It changes like every 6 months. I've watched it happen for 3 years now. What was once a pretty nice deal 3 years ago is like barely a nice deal now. So it's hard to keep up with it, and for that reason, I suspect it's pretty inefficient. But that's not the student athlete's problem.
Question. Before I make the question, I'm not a lawyer, so not even going to go there. There's something in California called California Lawyer for the Arts, which is a nonprofit organization. This year is their 50th year of existence, where different lawyers in the fields of the arts, and when I say the arts, meaning the entertainment industry, come together and provide on an ad hoc and a conference kind of basis here, information that their clients or future clients could get insight and advice because they can't afford the hourly, whatever the rate is in Hollywood. But these particular entertainers or producers need access to information. So that the lawyers provide on a volunteer basis on their nonprofit status. My thing is there such thing as, not just California, but I'll say starting with California lawyers for NIL, where you look at who are the clients who really need you but can't afford you. I think it was mentioned on the panel earlier how parents, guardians are a big part of needing this information because they become the first door of where you engage that student athlete. And I will leave it there.
So I can take that one. I've dealt with California Lawyer for the Arts, both as the director for the West Coast of the USPTO and in NIL. They were attempting to work with several colleges, and it went bad, very bad. So California Lawyer for the Arts, to justify its nonprofit status, has a federal poverty limit, for all of its clients. Wasn't a problem at all originally because nearly every student fits in that definition. But then they said, wait a minute, no, we have to roll parental income into that in the form might as well have been a mortgage. And so it was so high friction, and basically just started throwing students out. And it turned out there was actually no one that it could help anymore. And the idea of it is great, but when you get into any of the pro bono associations, that federal poverty limit and how the executive director chooses to define that around students will either make it work or kill it. And that's, other states have similar issues from what I've understood.
That's all we have for today. It's 12 o'clock, but I want all of you to thank our panelists. We have lunch in the other room, and we'll see you back in an hour. We also have our keynote speaker, Nancy Skinner, who will be there. Oh, here for lunch. Okay, go to the room and then come back here for lunch so you can sit down and enjoy everyone's company.
Okay, so I know we have a special lunchtime visitor and guest speaker. And actually, it's somebody I think you've heard a lot about this morning. Senator Nancy Skinner from California. She was actually the author of the Fair Pay to Play Act, which we've talked a lot about this morning. I'm sure we'll talk more about this afternoon. And I want to read a little bit of Senator Skinner's bio here. She's done a lot of firsts, too. I didn't realize until I looked at her bio. Interesting. She's a social justice and equal rights advocate, environmental trailblazer, and champion of the criminal justice system reform in the state of California. And she's been there for over 14 years. Serving the great state of California. She's a graduate of UC Berkeley, and she began her public service in 1984 as the first student elected to the Berkeley City Council. So without further ado, I'd like to introduce and ask Senator Skinner to come up and give us a few lunchtime remarks.
Great to be here. I was able to listen to some of your last panel, but I wasn't here earlier, so I'm not sure, other than looking at your agenda, all that you've covered. But I think it's really good that you're gathered and talking about this because clearly, so the bill I carried in 2019 was the first, SB 206. It was the first in the country to give college athletes, and thus even high school athletes, though it wasn't explicit about high school athletes, but we'll get into that in a minute, their name, image, and likeness rights. And at the time when we did it in 2019, in the NC2A, of course, 100% opposed it. The colleges and universities all opposed it. Everybody to do with the infrastructure of this multi-billion-dollar business of sports opposed it, except for some agents, they wanted it, and then, of course, the athletes themselves. And then all of the families of athletes who said, yeah, you know, like our kids are getting screwed. But the NCAA threatened California and said that if we pass that bill, they will prevent our colleges and universities from being able to participate in playoffs. Which, of course, that's a pretty serious threat, you know, because a lot of what you're trying to do with your team is get into those playoffs, right? You want to be the number one victors. And so it did not make my colleagues in the legislature nervous. I almost got a unanimous vote in both houses and every time that we brought it through. And anybody who's familiar with the legislative process knows that you have to go through a lot of committees. You have to get on the floor of both houses, meaning Senate and Assembly, to get approval. And yet, you know, it was pretty much universal. I think we had maybe one no vote in the process. A couple people have stayed off. And a lot of it was, and in the committees, my colleagues, Republican and Democratic alike, would testify. They'd say, you know, I talked to the expert, the best expert, and that was my son or daughter who's in basketball, volleyball, softball, whatever, is in different college sports or fans of college sports, and every one of them said, yes, you've got to do this. We're being screwed. And so my colleagues all were like, yeah, well, my expert advised me, and so I got to go with this. I got to vote. And anyway, but the administration, meaning Governor Newsom's office, was nervous about these threats. And of course, all the trustees from Stanford, from USC, you name it, we're all calling him and saying, you're going to ruin college athletes. And of course, now, did they know that the Pac-12 would fall apart, or our conference? At the time, no, and it wasn't due to NIL. So, really the big impact on California's colleges has been that conference falling apart rather than NIL. But anyway, we'll set that aside for the moment. So the governor asked me, would you put a delayed timeline in for implementation? And usually, hey, when a governor asks you, since the only way your bill becomes law is if they sign it, you want to consider it. But also, the other factor that was happening at the time is you had the NCAA was under many lawsuits, as you can imagine. The O'Bannon case had already been settled, and the O'Bannon case was really about NIL. though the settlement of the case did not grant all athletes NIL, but at least forbade, say, the video games and such from using the image or likeness without the athlete's permission, and in effect without sharing some revenue. And there were other lawsuits going on, and mostly the antitrust lawsuits. And Judge Wilkin, Claudia Wilkin, was the primary judge in many of these and is in the key lawsuit today, which I'll get into in a minute. So I knew that the landscape was changing. Plus, once I introduced my bill, all of a sudden many other states started following. So I figured, okay, I'll put in this delay in implementation. We'll see what the NCAA does with all this onslaught of other states. And if they don't change their rules, since I knew that I was going to be continuing in the legislature, I could always go back and put in a new bill that put the date, move the date up, which we ended up doing ultimately. So it was passed in 2019, and the date we put in the original bill to go effective was 2023, but then the very next year, we put in a second bill that put the effective date into 2021. So, because all the other states were having that effective date of 2021. And then, of course, the NCAA themselves folded, meaning on this issue, not entirely, which personally I think they're a useless organization. And it would be okay if they folded, but we'll get into their little bit of history too. So basically, until my bill, college athletes were the only people in the US, the only student, the only anybody who didn't have their name, image, and likeness rights. Now, I'm not a lawyer. So when this concept came to me, I had no idea about it. We take for granted. Anybody who isn't, study law or whatever, they don't think twice about, somebody using my name, image, and likeness against my will, except, of course, we see it within, this is the issues around internet privacy and such. There's lots of now privacy issues as our images are, becoming so much in effect, the public domain. But before that, people weren't really thinking, this concept is, you just took it for granted. And, but the fact that you as a athlete, even in high school, had to sign something, in effect, giving up that right, it's just outrageous. And what was the history of it? And the history of it is this legacy of amateurism that was created by colleges and the NCAA when it formed. So back in, I don't remember the exact year, but it was the 20s or 30s. And they did that because, interestingly enough, if you look at the history, there were some colleges that paid the student athletes because it was generating revenue for them. And then there was a whole issue of, are they employees? And if they're employees and they get injured, will we have to provide them workers' comp or disability rights, disability pay? So the whole thing of trying to create this status of amateur athlete was to avoid having them classified as employees and workers' comp and disability pay. So totally designed to screw the student athletes. And of course, as time went on, we're talking about a multi-billion-dollar industry. And those of you who follow it know that the highest paid public employees in states like California are college athletic directors and coaches. Not the UC presidents, not the chancellors, but these coaches and athletic directors. And what is the, what's all the revenue generated from? The work and the talent of the student athlete. They're the labor. So you can see why I don't like the NCAA. Amateurism was about exploitation. And I've given you a little bit of background. So my exposure to this issue, I'm a sports fan, but mostly basketball was always and college basketball. And so even back in high school, my favorite athlete was then Lou Alcindor, now Kareem Abdul-Jabbar, and he played for UCLA, then Lakers, of course. And, since I was young, Kareem would talk about the exploitation of black student athletes. And the fact that our bodies, meaning the black athletes' bodies, generate all this revenue, and what do we get? So it was something that, but I very much, in my kind of construction of it, it was about exploitation of black student athletes. I didn't really think about athletes in general. And of course, that was also brought home to me where, hey, I went to Cal. Who was the professor there? Harry Edwards, famous sociologist, and also was an athlete himself. But he is the individual who organized the 1968 protest at the Mexico Olympics, where black athletes, led by Tommy Smith and Juan Carlos, and most of them were from right here at San Jose State, basically said, hey, we couldn't even afford to come down here. And then we're going to go home and continue to play at our schools. And they were mostly track athletes and just continue to get screwed. We can hardly even, I would read stories about them. And the cafeteria workers would pack up all the food that was left at the end of the day and send it home with them, because that's the only way they even had food, like over the weekends, or could feed their families. That's how, desperate their circumstances were. And yet the colleges, of course, were getting this huge benefit. So this was the orientation I had. But I didn't think about it beyond, well, what do we do about it? Now, I was I got elected to the California legislature originally in 2008 in the state assembly. I didn't think about this issue much then. But then when I was running for the state senate, so I was running for the senate in 2015, 2016, I was a member of the Oakland Rotary, and I went to a Rotary meeting. It was traditional that the Rotary Club, and this will be coming up very soon, they have a big thing about the big game, and they always have they have the Cal band come and play, and then they have a speaker who talks about sports. And at that particular Oakland Rotary meeting, Andy Schwartz, who's a sports economist, spoke. And Andy he tends to be an expert witness at a lot of trials. So he was an expert witness in the O'Bannon case. So Andy Schwartz basically came to that meeting and talked about the exploitation of student athletes. But of course, he was talking about it much broader than just black student athletes. He was just making the case for how this billion-dollar industry and, how students are the ones who don't benefit, other than a scholarship, which in many cases is not even really cover their expenses, and in many cases would be even taken away, say if they were injured and then not playing, so then they don't even continue with the scholarship. So he was describing all this, and when it was over, I pulled him aside and I said, hey, I'm running for the state senate, and this is an issue I've thought about a lot. Is there something I could do as a senator? Can the state do something about this? Or are we preempted? Because I didn't understand the legal, issues around it, like whether states were preempted, whether there were national laws. And he goes, no, there's no national laws. And he said, in fact, the NC2A, he goes, this is all rules of the NC2A, which all the colleges basically join and ascribe to. But the NC2A's own charter basically says that they must follow state law. He goes, so if a state changed the law, their law, then the NC2A has to comply, at least for that state. He goes, so yes, you could change it. Now, my first approach, what I wanted to do, now again, some more background. When I was a grad student at Cal, I was one of the organizers of the first TA union. So now all grad students, postdocs, researchers, TAs, you name it, are all unionized across the country pretty much, but all through California. And that first union was formed at Cal as a TA union in the mid-'80s. So that's where I came from, was, hey, give the students collective bargaining rights, let them get paid, and then they can be covered if they get injured. So that's what I wanted to do. But when I got elected and I sat down with my staff and said, we're carrying a bill, we're getting students paid. They're like, oh, this is so complicated. They're like, oh, you can't do that. No, you're crazy. So whatever, I backed off the first year. Second year, I get elected in 2016. Second year, I say, hey, I want to pay student athletes. And they're like, no, you don't. Do you know what you're up against? the colleges, the NC2A and all. And of course, I didn't follow the NC2A at that time. I'm like, yeah, who are they? So then the third year, I sit down with my staff. I said, look, you have told me for 2 years in a row I can't proceed with the bill I have in mind. I am going to proceed. I'm going to get it introduced unless you come up with an alternative. So that's when, and of course, when we looked at trying to set it up for students to just be paid and give them collective bargaining rights, it was more complicated. It's legally more complicated. And not impossible, but was legally more complicated. So they spoke to my staff, reached out to a lot of people, Andy Schwartz, to Ramogi Huma. Ramogi Huma is, he is the founder of the, Bob, remind me the name of the organization he's the founder of. The Athletic Collegiate Players Association. So in effect, like the Association of College Athletes. And so Ramogi, Andy, and others said, look, what you should do is give the students back their NIL rights. That's the first step. Do that. So that's what we did. That's why we introduced the bill. And as I mentioned, we got great, great support. Let's see where we're going to go next. What was interesting when I introduced the bill is I thought that I would hear from, our office would be called by a lot of these student athletes who, there were already many that were very famous, that couldn't monetize the fact that they were, this fame. Now, of course, as we well know, a lot of them were getting paid under the table. That, of course, got exposed. And maybe that's why not too many of the male student athletes ever called me. Maybe most of them were being paid under the table. I don't know. I don't go and ask. But who called my office? Women athletes. I couldn't believe it. It didn't even occur to me. They call me. And so Erin Cafaro, for example, who's an Olympic rower, I think at least minimum 2-time gold winner, rowed with Cal, stayed in school to continue her rowing career because she couldn't afford all the equipment and everything to keep up with rowing without being a student, and because she couldn't really monetize even though she was an Olympian. So she called me right away. And then Haley Hodson, who was a volleyball player at Stanford and the #1 seed across the U.S. at the point that she was recruited for Stanford, but in her first year had a series of injuries where there were concussions to the head and then couldn't play. But even in the beginning of her career, given her, how much in demand she was as the volleyball player, she was approached by sunglass companies, by all kinds of companies where they wanted to sponsor her, and she couldn't say yes. But she also knew, when she came to me, she said, look, Nancy, given the lack of professional opportunities for women in sports, I am at the height of my marketing ability as a college athlete, and yet I'm denied to utilize that. And then, of course, meanwhile, this is going on. And I don't know how many of you remember, but I believe it was in the American Idol. There was this student at Cal, UC Berkeley, who used to sing in Sproul Plaza. The guy could not sing worth shit. He was flat, he could not sing. But he was, a phenom, right? So he was interesting. And he made it onto American Idol. And he then, of course, monetized himself on social media and such, and the guy was making millions. Meanwhile, Caitlin Ohashi, the brilliant gymnast at UCLA, had over 1 million YouTube viewers and could not, for her floor routine, and could not monetize it. So I'm watching this, and everything Haley is telling me makes total sense. So Haley and Erin Cafaro were 2 of my key witnesses in the committees. I didn't have any male student athletes. It was the women student athletes. And when NIL finally came through, women were some of the highest beneficiaries. And you probably just saw in the news that Kalina Smith, who's a player from Ontario Christian High School, just became the first women's high school basketball player to sign an NIL deal with Adidas. And Candace Parker is who signed it. So there's just broke that news. Now, so women initially were some of the best beneficiaries. But then some things happen where, now it's a little bit, we'll get into that in just one second. But anyway, so it was women who came forward. And as we know, the bill changed the world of college sports. So, what's happened now? Yes, women have benefited. NIL rights are arguably why this year's March Madness, more eyes were on the women's finals and the women's semifinals for basketball than any other college sports event yet, ever. Now, a lot of that was those players, whether it was Angel Reese or Caitlin Clark or various others, had been able to promote themselves and already had deals and they were smart. They already had huge social media followings. So, of course, we were all paying attention to them, which is then why we watched them. Their schools and the NCAA did not promote women's basketball. We remember what happened in past years. No, it's the women players who promoted themselves and brought our attention, and that attention's continuing. But meanwhile, what's happened in this landscape? Yes, as is still the case, colleges still generate the most revenue from male basketball, male football teams. And so it becomes like this self-fulfilling prophecy. And then they create, these collectives have been formed. The collectives are not technically formed by the colleges. And they can't be. So like under California law, while the college can help a student and give a student an NIL right, and I'll explain that in a second, they aren't allowed to, set this, keep this thing about these boosters who would then, like what used to happen, which pay under the table to recruit the student athlete. That's supposed to still be pure and clean. Anyway, so these collectives got formed, and these collectives are these boosters. And the collectives then, Nike sponsors the one for Oregon, and they are mostly providing offerings to male students in football and basketball. So it's question mark, and you're all in law school, maybe most of you, many of you lawyers. I want to see when Title IX is going to come to play. And I carried a bill this year, which the governor vetoed, where I would have required disclosure on what the NIL deals at each school and where they originated. Because I wanted to see. I think, it's to me, I don't want, again, we should not make assumptions, but I'm going to make the assumption that most of these deals are going to the male student athletes and not to the females. And so the women are on their own. Now, fortunately, like in the case with Adidas, they're seeing that, hey, women's sports is growing. It's becoming economically valuable, but let's make sure it does. So that's a big issue for me, because I want to make sure there's some gender parity. Anyway, the next frontiers in this whole circumstance is NIL rights, from my point of view, need to stay, should stay. They were not a mistake, but they are not enough. Athletes should still be paid. And they should have better rights because, for example, when they're injured, what happens, right? While we have all kinds of athletic or student bills of rights, which are supposed to, maybe colleges continue their health benefits for a year or something, but we know many sports injuries can be chronic or can be much longer lasting than just a year. So, we have, if a college is making tons of money and effect off that athlete, they have a responsibility in my mind. And I think all of us. So anyway, current federal lawsuits are going to be a big factor. We've got the House versus NCAA right now. That's the biggest one, again, with Judge Claudia Wilken, who's already shown her hand multiple times with several rulings against the NCAA, including the O'Bannon case, where she ruled that college athletes are not amateurs, and they had the right to capitalize on their own name, image, and likeness. And the negotiations on that lawsuit right now will likely result in revenue sharing, which in the dollar amount they're talking about is in the billions. So it could be $20 million a year per school shared amongst athletes. Meanwhile, the NLRB, that's NLRB, National Labor Relationships Board, right, ruled that student athletes may be employees of their college or university. So they basically said, no, this is allowed. And that was in a Dartmouth case. So the Dartmouth student athletes started organizing to be employees. And right now there's this other lawsuit, or at least the NLRB is doing a hearing regarding a case against USC and the Pac-12 around their definition of basically excluding student athletes from being employees. And around that issue, the U.S. Supreme Court did not block the case. And Kavanaugh is the one who led in saying why. So it's interesting to see what this Supreme's, how they may respond to some of this. And then finally, I'll mention that I said that colleges can do direct NIL deals, which they can. Colleges, well, first, they could employ their athletes, but they also can say, if they have a student athlete who is, generating the most interest, say, around in their particular sport, they could say, look, we want to market you. We want to sell your caps, your T-shirts, or whatever at our student store, and we'll share the revenue with you. Because still today, at the University of UConn's bookstore, Diana Taurasi's things with her number and her name are still the biggest sellers at that bookstore. So imagine if she were just generating, still receiving the benefit from it, versus her pay in the WNBA. But anyway, so that's something, and I've been promoting that with our universities and colleges in California to get them to do more of that. And then one of the panelists mentioned earlier, this also enables not just, in other words, having the name, image, and likeness rights removed the restriction that the NCAA had on, say, if you were a swimmer and you wanted to be a lifeguard or a coach or give swimming lessons, you can do that now. You could be a coach for an amateur and be paid. Any student athlete now can be employed using their talent and skill, whereas they couldn't before, except for golfers. Golfers were given an exception. So anyway, that's, I'll stop there, and if I don't know if will allow questions or, yeah.
Right. Questions for the senator?
You can ask me anything. And like a politician, whether I answer it or not, it's another story. But
You're pretty unfiltered, so yeah. That's right.
Yeah.
Hi, Senator Skinner. Thank you so much. You brought up the gender inequity piece to NIL, which we will be talking about at a panel later. But I'm curious from your perspective, I think NIL disclosure, which unfortunately was vetoed, is one avenue. Are there other ways that you all have been strategizing in terms of enforcing or helping protect female athletes, especially from these collectives that seem to be disproportionately
benefiting
male athletes? And
yeah.
and as a former female athlete myself, I think it's hard to see that the future of this won't just replicate some of these really serious inequities we've seen play out over and over again in our history.
So I think somebody needs to come forward with there's a whole question as to, some people think that Title IX should apply and does apply to these collectives. Others say not. So we need a legal case to prove whether. I think that needs to happen. I was hoping that by the disclosure, that could help lead to that. And it may be why, I'm not saying that Governor Newsom was afraid of that, but the colleges are feeling a bit bruised right now. So they're kind of like, don't put anything more on us. We don't. But I think somebody needs to, and advocates of Title IX need to bring this forward and test it. And I hope that it would indicate that, in fact, Title IX is applicable here so we could get some fairness. Otherwise, all the other landscape of NIL is completely available to the women athletes, but it's sort of it's just based on their entrepreneurial skill. Now, there are a lot of agents who are, because women's athletics is becoming more and more popular, many more eyes watching different women's sports. The agents, of course, you know, they love that. They want to make money, so they'll approach women athletes. But it would be much more fair if, number one, our colleges and the NCAA gave the same attention and investments in women's sports as they did the male sports, because, of course, you know, the money follows, right? And also that these collectives did. But in the meantime, women can still use their entrepreneurial skills. Social media, you name it.
Thank you, Senator Skinner. My question, and first, I remember where I was when this bill was signed, so it's pretty cool to see you in person. So thank you again for your advocacy for our college athletes. Given that you're paving the way, what is next on your agenda for continuing to advocate for our college athletes?
Well, California has term limits, and my expiring, my shelf date is November 30th. So I will not be in the legislature, but there are other members of the legislature. So, hey, good people like you can approach them and give them suggestions.
Thank you.
Hi, Senator Skinner. It sounds to me that there seems to be some sort of disparity in education around name, image, and likeness, and especially with collectives and things like that. And it seems like there are things that student athletes should know about. That was something that was brought up a lot during the panels. What ideas or suggestions do you have in ways that we, even fellow students, because I'm a law student myself at the moment, ways that we can help educate these student athletes to maybe begin to advocate for themselves or learn these things on their own, not completely remove us from the equation, you know, but how can we help them?
Well, if you do a search on either websites for student athletes on NIL or advice for, you will find lots. There is lots. Now, you know, a good amount of it is entities that are going to try to make money off the student. Some are not. Many colleges now are offering seminars and courses for the students, but I'm kind of, I don't want to assume. Look, students were marketing themselves, non-athletes obviously, but hey, computer science students were designing video games, were getting patents, were, you know, making all kinds of money even though they were still in school as computer science students. Music students were using their music skills, and whether they were, just trying to break into professional artistry or whether they were doing it through social media. So I don't think, I'm not a fan of in loco parentis. I'm not a fan of assuming that any student doesn't know, you know, what, but certainly we're all differently oriented in terms of entrepreneurship. So I think that is helpful to, you know, give students some support that way. And I don't have a problem with any of the colleges that have seminars and such on it. But there is a lot of resource out there on the issue.
I think that might be it. Okay, well, thank you, Senator Skinner.
Welcome.
That's really cool. Awesome.
It is my pleasure to introduce to you Jason Lott. Jason Lott is the managing attorney for the Trademarks Customer Outreach at the USPTO, where he specializes in helping small business owners understand trademarks and the federal trademark registration process. He creates and delivers educational content using live presentations, creative videos, and other multimedia platforms. He also presents to experienced practitioners on advanced trademark topics, providing them the tools and expertise to better serve their clients. Jason began his career at the USPTO in 2000. as a trademark examining attorney. And I would like to personally add that the content that Jason and his team produces is truly great, and it really benefits my students. And I must say, you know, when I first stumbled upon these videos, these government videos, I was a little bit hesitant, but I was very surprised at how fun and easy to follow along they were. And so please know that this content does exist. And I would also like to add, and I know this has been mentioned a few times throughout the conference, but the USPTO has a fantastic program called the USPTO Law School Certification Program. And you could look it up on their website, but this allows law students to file patents and trademarks under the supervision of faculty supervisors on a pro bono basis. So there's about 70 schools participating in this program across the nation. And so there is this pro bono support out there to help you navigate this complex landscape. So we here at USF are part of this program, and also, I believe Professor Faucon at UConn, she's part of the program. Her clinic is part of the program. And so please don't hesitate to reach out if you need pro bono support. And our clinic at USF will be taking applications in January. Okay, Jason, take it away.
Thank you very much for the work that you do in the law school clinic. Are these a lot of law school clinic people over here? No? We got one. Okay, thank you. Two. Okay, we got a couple of them. Okay, cool, great, thank you. Thank you for the work that you do, especially providing free assistance, legal assistance for the folks who need it. And thank you for those very kind words. We're gonna dive right in to a topic that is part of NIL. Sometimes people do think about NIL and they immediately assume that it involves trademarks. That can or cannot be true depending on the circumstance. So what I want to do today is kind of talk us through some trademark fundamentals that you might want to know as a student athlete, or perhaps as a parent, or a supporter, or someone who just cares about student athletes, or someone who just wants to learn more about it. So what we're gonna talk about today are some trademark fundamentals. We're gonna talk about some common trademark considerations for student athletes, because it's different for student athletes. The things that you as a student athlete might need to know or to think about when you're thinking about trademarks and potential trademark protection, it's different than, say, being a big business out there. So there are very specific things that you are going to want to keep in mind. And I'm also going to give you 3 trademark takeaways. Okay, so let's dive in and let's talk through some trademark fundamentals. Now, we can make this as interactive as you want it to be. Okay, so here's what I want to do right now. I want you all to take a look at the screen, and this also goes for you folks watching from home. I see you there in the camera. Thank you very much for being here today. So what I want to do right now is I want you guys to take a peek at the screen, and up in that top left-hand corner there, you might see a logo that you recognize. Anybody want to shout out what that company is? Oh my goodness, you guys. That was so depressing. Apple. Okay, cool. Yes, it's Apple, right? Okay, so when you see that Apple logo, tell me, what product or service do you immediately think of? Phones, right? Anybody else? Tablets? Laptops, earbuds, streaming services, music, all that sort of stuff, right? So as soon as you see or hear or experience that logo, boom, you automatically think of Apple's very specific products and services. Same thing is true with Coca-Cola. What product do you think of? Yes, a sugar, yes. One component of the soft drink, yes, right? Okay, so you automatically think of Coca-Cola's product, right? Not Pepsi-Cola's or RC Cola or Dr. Pepper. You think of Coca-Cola, right? Same thing with McDonald's. You see the arches, boom, you automatically think hamburgers, right? Or restaurant services. You see Amazon, boom, buy whatever you want in the world and get it in 2 days. Or 2 hours, you know, depending on, this is San Francisco, maybe you get in less than that, all right? You see the word Google, search engine, Samsung, personal electronics, Microsoft, hardware, software, Nike, shoes, Ford, trucks, right? You get it. every single time you see or hear or experience that trademark, it automatically calls to mind in your head those very specific products and services. And that relationship between the trademark that you are seeing or experiencing and that underlying product or service is key. Without that relationship, it is not a trademark, right? It's just a bunch of words, maybe a kind of cool looking pictures or logos. That's it. It is not actually a trademark unless it is actually indicating source. Because if you want to talk about the more legal definition of what a trademark is, it's any word, symbol, design, or combination thereof that essentially does two things: identifies the source of products and services and distinguishes them from the products and services of another party. I think the easiest way to think about it is to think about the last time you went into a restaurant, or was it you, sir, when you go to Levi's Stadium and you get Pepsi, right? You're like, hi, I'd like to have a Coke. And they say, sorry, sir, is a Pepsi okay? And you say, no, it's not, but I'll take it anyway. Right? So that's what's happening there is you were using a Coca-Cola trademark to indicate the source of the product that you actually want. And the waiter or whoever's behind the counter is using for example, in this case, the Pepsi-Cola trademark to indicate the source of the products they actually provide. And both of those companies are using their trademarks to distinguish their products from each other so you don't get confused when you go into the store or you're at a stadium or at a restaurant or something like that. Does all that make sense? Yes? Yeah, I even got a thumbs up from down front. Thank you so much, appreciate that. Okay, but here's what I want you to think about, all right? Is because sometimes they're your marketing people that you're going to be talking to, right? As a student athlete, you're probably going to be talking to some people who are like talking about your marketing, right? Here's what we're going to do, right? So when they see you, what do people think of, right? What they're talking about really is the feeling, right? What is the feeling that the brand creates when they see you appearing in a commercial? Like, oh yeah, I do trust them. I do want to buy their pizza, right? Or whatever it is. I do trust her. I guess I will go to that muffler shop and get my muffler redone, or whatever it is, right? So it's about protecting the feeling, which is very hard to do. So instead of protecting the feeling, what do? You use a trademark. And so the trademark is what is providing legal protection for your brand. And as a student athlete, you might want to be thinking about what your brand actually is, right? And what is the thing that you use to help identify you and your services in the marketplace. That's going to be your trademark, and a trademark is something that you can potentially protect. And we can talk about sort of how all of that works, especially if you're at the, say, high school level, university level, maybe you haven't made it up into professional sports yet, but you might be thinking about it, that sort of thing, okay? Any questions right now about what a trademark is? No? Okay, good. Let's talk about why they might be important. Okay, so at the USPTO, the United States Patent and Trademark Office, one of the things that we don't do is actually value brands. Okay, that's not what we do, and there are private companies out there that do this. And the reason I'm showing you this slide right here is because I want you to understand how valuable trademarks and brands can actually be. So this was done by a private company called Interbrand, and they valued, it's kind of hard to see, it's kind of washed out right here, but they valued the Apple trademark from last year at $502 billion. Okay? That's the value of the brand, of their trademark. It has nothing to do with the actual products themselves, or the actual building, or the desks, or the computers that they use, or the cabling, whatever. It's the value of the brand alone. Same thing with Microsoft, $316 billion, Amazon, $276 billion, Google, $260 billion. Again, just the value of the brand alone. Now, with you as a student athlete, does that automatically mean that your brand is gonna be worth $260 billion? No, of course not, right? But they do have value, and that value could be something that translates into more dollars for you in your NIL contract. Okay? So this is one of the reasons why it's important. A lot of times people don't think about trademarks. Look, this is all businesses, okay? It's not just student athletes, it's all businesses. when you're building up your business, one of the last things you might be thinking about is your trademark. But in some ways, it should be one of the first things that you're thinking about. Okay, so let's talk about what a trademark does not do. Okay, so a trademark does not mean that you legally own a word or a phrase. It does not mean that you can stop other people from saying that word or that phrase. And it does not mean that people owe you money if they say that word or that phrase. I have heard that before. Hey, Jason, if I trademark this, that means anytime somebody says it, they owe me a nickel. No, sir, that is not what that means, okay? Let's take Apple here for an example. Apple Inc. has a federally registered trademark for Apple for their products, right? Do they own the word Apple? No, right? Can they stop me from saying the word Apple? No. Apple, 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 right? No, they can't stop me, right? Do I owe them money at this point? 45, 50 cents because I said the apple so many times today? No, of course not, right? But what they do have is the exclusive right to use the word Apple to indicate the source of their specific products and services, right? So if we decided we were going to invent a new smartphone, could we call it an Apple phone? No. Well, we could try, and then Apple would come after us, right? Yeah, we want to avoid that situation, right? So we would have to come up with something else to use as our trademark because Apple is the one who has the exclusive right to use that. And so think about that as an athlete. What is the thing that you are using to help your potential customers out there? And customers could be somebody that you have a contract with, or the customers of the people that you have a contract with for your NIL rights. Okay, so think about what is making you unique and is helping to separate you from other athletes and from other competitors who might be doing something similar to what you are doing. All right, so let's talk about what I like to refer to as the big three of, it's kind of similar to the Big Ten in that it's no longer 10 teams anymore. So, this is still kind of three, but there's other things I'm going to talk about too. But this is what I like to think about in terms of trademarks and the things that we are typically have coming to mind when we think about trademarks. We think about brand names, slogans, and logos. And sometimes people do get these confused. They're like, oh, hey, Jason, yeah, so I already have my logo, but I think what I also need is a trademark. Nope, that actually is a trademark, right? Yeah, but I've got a slogan. What about my trademark? Nope, that's also a trademark, right? So if we think definitionally about what this means. So let's take a peek at a brand name here. Down in the bottom corner there, Zags, right, for Gonzaga, right? That is one of their brand names. And they have protected that word with our office for their specific products and services, right? It's probably educational services, athletic, services, whatever. Also, probably they have it protected for their various bits of merch, things like that. So they have protected the word Zags. You, as a student athlete, could also potentially protect your brand name as something that indicates the source of whatever product or service it is that you provide, okay? There's also things like a slogan. Maybe there's a particular slogan that you've come up with. Maybe it's, the chant or the cry that you have before you, start a game or something like that. This one here, Rock Chalk Jayhawk, all right? That's another federally registered trademark, another slogan that has been registered. So those are also protectable. And there's also things like logos, right? So we can see here the ASU logo with their sort of like sunburst logo. So these are the more traditional sorts of things, brand names, slogans, and logos. A couple things I will point out right here. I won't go into it too in depth, but you can see those words up there, and they're in Times New Roman font. Do we ever see those trademarks out there in the real world in Times New Roman font? No, right? We usually see them some other way. But I'll tell you right now, this is how they registered those trademarks with our office. And they did it that way for a very specific reason. Because when you apply and register your trademark in what is called standard character format, what you're getting protection is for the wording itself. Not what it looks like, but for the wording itself, which is actually incredibly valuable because it means over the life of this trademark registration, they can put it in whatever font, style, size, color they want to and still have protection. When they submit their evidence to us to say, hey, USPTO, yeah, I'm still using Zags as my brand name, we say, cool, well, I don't care what font you put it in. Look, Gonzaga, you wanted to put it in Comic Sans. That's your choice, man. You know, we're not going to judge you, but maybe we'll judge you a little for it, okay? But we're not going to say anything. But you can actually put in whatever font style you want to, and you're still going to have protection. Same thing is true over there in the bottom. There you can see the ASU logo. It's in black and white. If you think back to all those logos that I showed you on the very first slide, how many times have you seen those logos out there in the real world in black and white? Pretty much never. Maybe the Apple logo, right? But also here too, that is how they registered their trademarks with our office, without color. Because it means over the life of the registration, they can put in whatever color they want to, and we're not going to say anything about it. When they submit their evidence to us, you know, ASU, perhaps that's always in, it's red and yellow, but I know it's more precise than that. It's burgundy and maize or something like that. I don't know exactly what it is. It's not the same as burgundy and gold, or scarlet and gray. But they're probably going to use it in those colors. But by registering it without color, it's giving them protection if they want to change up the colors. Maybe ASU at some point decides, you know what, we're going to put it in pink and purple. We're going to do a little color change here, right? So you're going to have an increased scope of protection if you're registering your stuff without color. Does all that make sense? Yes, I'm seeing some nods. A couple shakes of the head, but I'll talk to you afterwards, sir. Okay, cool. So here's the other thing, right? So it doesn't just have to, thank you, Amando. So it doesn't just have to be a brand name, slogan, or logo. You can actually register a sound. So can you go ahead and play it for me? Nope. Can you play it? Can you push it on the laptop? Thanks. There you go, right? Cool, thanks, Amando, appreciate that. Dr. Harry, I should have had you get up and do it. I see you over here.
2 years, it's very strange.
So as you can see right here, Arkansas has registered the sound of this chant, right? And the reason that we have this little video right here is because when they applied to register with us, we're like, there's no evidence of this. And so what they actually did was I think this was the president of the university at that time. He's like, okay, here's what we're gonna do. We're gonna have a big thing and we're gonna film it and we're gonna submit it to the USPTO so these guys will give us our registration, okay? So there's things like sound that could be registered as a trademark. I'm not the best singer in the world, but some of you might recognize bum, bum, bum. It's NBC, okay? I'll tell you right now, that's supposed to be NBC, okay? For those of you who are old enough to remember the internet when it first was really becoming public, Yahoo had Yahoo, right? That was also federally registered trademark. The Amazon, it is now Amazon, but the lion roaring at the beginning of an MGM movie, that sound, also federally registered trademark, okay? So I want you to think creatively about what it is that, maybe it's a sound that you make before a game or to get the team riled up, whatever it is. That's potentially something that could be registered as a trademark. It could also be something like a color. So anybody recognize the blue football field? Want to shout out who that is? There you go. How about this red and white football helmet? Alabama, right? Okay. Any Texas fans in here? Or you're like, no, we hate Texas, right? Hook 'em horns. Oh, we got a Hook 'em horns back here. Okay, here we go, cool. And also College of Charleston, their mascot, right? So again, we're getting into more stuff that might be a school is going to do, but I want you to think creatively about what it is about you as an athlete, or maybe about the company that you as an athlete are forming, because as we've heard all day today, athletes are businesses, right? You are an entrepreneur, even though you might not realize it yet, okay? So think about what you are using to indicate the source of whatever product or service it is that you provide. Now, the thing about it is that you don't have to have any of these things. These are the more non-traditional trademarks, but the reason I want to talk about them is because I do want you to think creatively. I don't want you to be locked into, oh, a trademark must be a brand name, a trademark must be a slogan. No, that's not true, right? There's all sorts of things that can be trademarks so long as they indicate the source of specific products and services. All that makes sense? Yes, okay, cool. All right, so let me do a little compare and contrast here between trademarks and NIL because it is important that we understand the differences. So a trademark is going to be that brand name, slogan, logo, or something else that is going to protect a component of your overall brand. But NIL is going to be protecting your right of publicity. Your trademark might include your name, image, and likeness, but NIL actually is your name, image, and likeness. And you can see down here at the bottom, for those of you who don't recognize the Jumpman logo, probably one of the more famous Nikes and Michael Jordan's logos here. On the left is the federally registered trademark. On the right is the image and the poster that that logo was actually taken from and derived from. So you can kind of see there is a little bit of overlap between these two things, but they're actually not the same thing. Okay? All right, cool. So let's talk through some common trademark considerations for student athletes. So there are some things that you want to consider when you're thinking about what your trademark actually is going to be, right? What is your trademark? What are your goods and services? Is your trademark too similar to someone else's? Is it distinctive? And are you using it ornamentally? There's lots of other things that you might want to think about, but these are some of the top ones. And just want to quickly go through them just to get your brains churning on some things that you might want to think about. So you might recall from that very first slide, we saw those non-color logos, right? And we talked about brand names and slogans and things like that. So what you need to think about is which version of your trademark do you want to apply to register? So let's say we have Dave Berdan sitting down here. You heard him earlier today. So let's say Dave is the student athlete, and his trademark is going to be. Can't tell you. That's his slogan, ladies and gentlemen. He says it before the beginning of every game. Can't tell you. Right? Okay. Right. So that's what it is. So Dave is going to have to figure out which version of his trademark he's going to register. Right? Maybe it's the sound version. Maybe it's just the wording itself, or maybe he's put it into a logo. Right? So there is that standard character format. Right? If he just wants the protection for the wording itself, regardless of what it looks like. Or it could be that, can't tell ya, like is part of a logo that's got his face on it, and says, can't tell ya, right? And it's the slogan that's on there. And it might be this special form format. So this, the logo sort of version of his trademark. In this case, you can see these are all three registered trademarks for Nike. They've registered lots of different trademarks with us over the years, different versions of them. These are three of them, and they're really kind of protecting different things. The Nike on the far side over there is protecting the wording itself. What you see in the middle and on the left side over here is more protection for what the trademark actually looks like. So again, you as the brand owner have options. You're not limited to just one thing. Oh, I can only do this. No, you can actually submit multiple applications to our office to protect sort of these different versions or formats of your trademark that you might be using. The other thing that I want you to think about is when we think about trademarks, we always remember it has to indicate the source of specific products and services. So think about what your goods and services are, all right? As a student athlete, your service is not sports, right? Or, if we think about Ken and Barbie, his profession was beach. Okay, right? That's not really a service. It's not really a product, okay? So you have to think about what you are doing as an athlete. Just playing a sport isn't actually a service. You have to think about what product or activity you perform for someone else. So oftentimes what we see when athletes and celebrities and entertainers and all sorts of stuff like that are going to register their brand name for a particular product, it might be something like the merch that they use it on. Right? It could be clothing, right? It might be a brand name. They've come up with their own line of shirts, pants, jackets, shoes, whatever, footwear, hats and caps, stuff like that. Okay, so again, we're identifying what product or service we use the trademark with. This is another one that a lot of student athletes are probably going to be doing with their NIL deals, and that's endorsement, right? So you're promoting the goods of someone else. The fact that you're playing a sport, again, not necessarily a service, right? But if someone is paying you, hey, in exchange for money or where did Joe go? In exchange for meal kits, right? In exchange for 10 meals a week, right? He's promoting the goods of someone else. Okay, so that's a service. An endorsement service is actually a service. Or it could be something like an entertainment service, like personal appearances by a sports celebrity, right? Maybe perhaps Dwayne Allen gets paid money to show up and sign autographs or something like that. So maybe you as an athlete are doing something like that. So there's all sorts of different things that you might be doing that are not sport playing, right? That are actually services that you provide. And there might be these products that you have your own branded products that you're putting your mark on. And that could be something that you identify in your application to register with us. Make sense? Right? Just remember, you got to tell us what your trademark is, and you have to tell us what product or service it is that you're providing. And it could be multiples of those. The other thing that I do want you to think about is making sure that you're avoiding a likelihood of confusion. All right, so now we're gonna get into a little bit of nitty gritty, and I hope you'll stick with me. I know it's right after lunch. I know, they took the coffee away. I know, I was looking for it. Okay, so bear with me, okay? Because now we're getting a little into the legals, okay? So when you apply to register your trademark with us, you are saying, hey, USPTO, I would like to federally register my trademark. And our examining attorneys are gonna say, okay, cool, let me take a look at that for you. And the examining attorney is gonna take your case and she's gonna look at a whole lot of different things, conduct a whole bunch of different tests. One of them is she's gonna look in our database to see if anyone else has already applied for or registered a trademark that is confusingly similar to yours. And she's gonna conduct a test which says, hey, are these two trademarks similar? And in addition, are the goods and services that are provided under those things related? Let me walk you through it, okay? So as you can see here, the test is not, are these trademarks identical? That's not the test, right? Maybe in a domain name situation where you're trying to register a domain and you're like, oh, I'm gonna put a hyphen in here and it's totally different, right? That's not what we're talking about here, okay? We're talking about, are they confusingly similar? Do they look alike, sound alike, have a similar meaning, a similar commercial impression? And in addition, we're asking the questions, if so, if these things are similar, are the goods and services that they are providing related? Let me give you an example. If I say the brand name Dove, what product do you think of? Shout it out. Soap. There it is. I was waiting. It's funny, soap always comes first, which, is good, right? It's good, cleanliness is good. Right? Yeah, soap, yeah. But there's always one. Thank you so much for the chocolate. Also, anybody want to say ice cream? Because they also do ice cream. Okay, yep, right. So here we have a trademark, identical trademarks, Dove. They can coexist out there in the marketplace because we as consumers are not going to think that the people who are making your soap are also making your chocolate-covered ice cream bars, all right? The last thing you want to do is bite into a chocolate-covered soap bar, right? So those things coexist, and we are okay with that as consumers because we're not going to be confused. Same thing is true with Delta. Anybody want to shout out a product or service when you think of Delta?
Faucets.
Airlines, faucets. Medical, yeah. There's a Delta Dental. Delta Van Lines. Any sorority? Tridel, right? Okay, right. So there's all sorts of Delta. Say it. What do you got, Gerard? There you go. Okay, see? Yeah, I know. It was so obvious. Yes, I'm so sorry. I stand here in shame. Right? So all of these things coexist. We don't get confused, right? Even though the trademark is similar. But what matters are, what are the products or services? Are they related, right? We don't think that an airline company is the same one who's gonna make the faucets that we're putting in our bathroom, right? Who wants to put an airline faucet in their bathroom? I mean, those things are tiny. Anyway, so we don't get confused as consumers, right? So think about this as a student athlete. What is your trademark and what product or service is that you are providing? Is it going to be confusingly similar to somebody else when these products are related? Anybody know football players, famous football players with the number 8? Steve Young? Mariota? Reggie Bush. Okay. Troy Aikman? Uh-huh. How about Lamar Jackson? Right? Lots of athletes out there, often known by their number, okay? And there's issues right now. I think it's Troy Aikman and Lamar Jackson are having a thing where they're like, hey, you know, I'm number 8. No, I'm number 8. No, I'm number 8, right? And they're trying to figure this out. And it's not because, we confuse those people, but it's because it is their trademark, 8. Well, sometimes there's some additional stuff with the 8, but it's also what products do they provide. Oftentimes it's going to be clothing or something like that. Right? So if you think about 8 as a brand, who does that really identify? We don't know. Okay? So that's an issue that they're having. So think about that as an athlete, right? Especially, are there any high school athletes in this room today? Most probably in the college to university. Sir, you are not in high school, okay? Okay, anyway, all right, so think about that. So if you're thinking about, like, what am I known by? It's my number, right? First of all, is that your number? And is it gonna be your number for your entire career from like high school into college, into professional sports? Probably not, right? So when you are thinking about what your brand is going to be, your brand name, your slogan, your logo, think about that. Is it something that is going to follow you? And is it going to be distinctive enough to not get confused with somebody else's? Right? So, yes, you have a question?
Yeah, I have a question about likelihood of confusion and slogans specifically. Because I think of 2 football teams. You have the Atlanta Falcons, whose slogan is Rise Up. Then you have the Arizona Cardinals, whose slogan is Rise Up, Red Sea. So it's similar goods and products, services, football teams. You think of the 2 things. What makes it so that way? Is it the addition of the term Red Sea at the end that makes it able to go through, or how does that work?
Love the question. I have to be a little careful because I cannot provide legal advice. Okay, so anything I'm going to say right here is not legal advice. I'm also not sure. It sounds like you're saying both of them are federally registered trademarks.
I'm assuming
right.
So.
They might not be. They might not be, right? So it's quite possible that they coexist because football fans are not going to be confused because they understand the difference between the 2, right? It might be that in this marketplace, it's okay for them to coexist because of that additional wording or something like that. So without actually doing a search on a database to know whether they are both federally registered, I clearly can't say, right? But your point is a great one because it does boil down to that. What are the differences, assuming the goods or services are related? How much is enough of a difference to differentiate you from your competitor? And I love the question too, because it also makes you think, when you're coming up with what your trademark is going to be, is there value in coming up with something completely different than anybody else, right? Or I'm not saying that either one of those teams are trying to draft along behind the goodwill of the other team. I'm not saying that at all, but you might want to think about what is a trademark that is going to make you unique that nobody else is using, right? Angel Reese didn't necessarily, I think, on her own come up with Bayou Barbie, but a lot of people referred to her as Bayou Barbie, right? She applied to register Bayou Barbie with our office for various products and services. It was refused because Mattel has already registered Barbie as a brand name for their various products and services. And so now Angel Reese is in the process of trying to, in some ways, rebrand with her nickname. Okay? So it's something that you want to think about. Even if you didn't come up with the thing on your own, it's just all of your fans did. It's something to think about because you want to avoid this situation where you can still federally register your trademark to get that nationwide protection that you're looking for. Make sense? Yes? Cool. Question in the back. Yes, sir.
Change it all with companies like Amazon getting into products that, they're
ooh, yes, nice
that,
and loud.
like Amazon Basics, for instance, right? They make a whole bunch of different products, And originally you wouldn't assume Amazon is making floss, but now they are, right? So it was like the examples with Delta and Dove and all those. Are those standards now being looked at differently, given some companies like Amazon that are getting into these areas you might not expect?
That's a really great question. The standards are always changing and are always in flux. And the reason that I say that is because there technically are no bright line rules. Every decision is factually based. And so what happens is, you apply to register, the examining attorney is doing a search, says, oh man, look at these both, Amazon Basics for this and Amazon something else for this. Maybe before it would have been fine, but because the marketplace has changed, that examining attorney can find all sorts of evidence that, yeah, I guess these companies that sell everything in the world, like on their site, they also do dental floss. There's lots of evidence. So we as consumers are now thinking, yeah, I guess if you sell everything in the world, you probably also do dental floss, right? So if the consumer mind changes based upon the evidence that the examining attorney is finding, then yes, the standard is changing. And you're absolutely right, that does change. If we think about Apple, for example, right? When Apple was first coming out with all their products, they had nothing to do with music, right? And there was Apple Core, right, which is the Beatles, right? And so, well, of course, there's no conflict here. Somebody's doing music, somebody else is doing computers. Why in the world would computer people ever get into music? Right? So times change, right? Things change. And so technologies also change. And so there's potentially going to be those issues where an industry shifts or lots of companies start doing more of one thing. It's a really great question. Thank you for that. Yes? Can you wait 1 second? Thanks.
Oh, hi, thanks. Woo! If someone files a trademark with the USPTO, how much protection do they get globally, like outside of the US?
Great question. Oh my goodness. Oh man. I love these questions. So a lot of the stuff that I typically do, I shortened it and changed it up for today. It covers this, and so I love the question you're asking because it's such a good one. The answer is pretty much zero. and that's because intellectual property rights are territorial. Okay, so they're always dependent upon the law in which you are operating. Same thing is true with patents, same thing is true with copyrights, trademarks are the same. Your rights in the United States are your rights in the United States. If you want protection in other countries, you need to file or register in those countries. As you can imagine, that's incredibly difficult, right, to protect yourself abroad. So there are mechanisms in place, a thing called the Madrid Protocol, which is it's not an international trademark registration, but what you do is based upon your registration here in the United States, you can use that in order to extend protection out into other countries. Now you still have to pay and all that sort of stuff, but it's a way to help you protect yourself abroad. So, does that help? Okay, cool, great. Awesome, all right, I love these questions, these are great. Did you have a question or are you just waving at me? Hello, hello, okay.
Thank you. My question is about common law trademark rights, and essentially, let's say one company lets their trademark lapse, right? It's then abandoned, and some other company registers a similar mark. It's a word mark only. Does that first company still have the common law trademark rights to even though it's registered, of a word mark that's used on the same article of clothing or whatever service is registered?
So let me make sure I've got the hypothetical down. Because it is a hypothetical, I'm not providing legal advice. Okay, so you're saying that there's a company that has been using a trademark, never federally registered it.
It was, but it lapsed, the trademark.
Okay, so, okay. So I'm out of here. No, so they were using it, so in addition, they federally registered it.
Correct.
And then they just didn't renew?
Correct.
Right, so they're still but they're still using it.
Correct.
Right, so they still have their common law trademark rights.
Correct.
Yep, which can be incredibly strong.
A second company then files a word mark that encompasses the words that were in the design mark of the first company, and then intend to use it on the same goods as the lapsed mark.
Sure. So the original party was still going to have rights in it because they can still rely on their common law rights, maybe through an opposition proceeding, maybe eventually a cancellation proceeding, something along those lines. So common law rights, although they are limited, oftentimes geographically, can be incredibly powerful. right? And you can use them to, in some ways, stop someone who is trying to register a trademark on top of yours. Here's one way I kind of think about it. Trademark rights are like, oh, there's Joe. Did you go get a meal kit? I didn't see you before. Okay. So I like to think about common law trademark rights as cake, and federal registration is the icing. Okay, you can rely upon the cake, and cake can be delicious. Okay, it can be even more delicious if you have icing on top of it, but it's not required. Okay, and so at some point you could say, you know what, I'm actually, I'm trying to watch this, so I'm going to scrape that icing off and still rely upon your cake rights. Okay, with your common law trademark rights, and they can still be very powerful even though you don't have federal registration. Just remember, federal registration is not a requirement. There's no law that says you have to register with our office. You could always rely on your common law trademark rights, and some people do. They're sometimes more difficult to enforce. You don't get all the presumptions, but it's possible. So, okay, cool. Oh, that's right. I was going to do examples. Totally forgot. I typically have notes in front of me. I don't. So here we go. All right, here we go, team. What's going to happen is, let's say that you wanted to apply to register T Markey as the brand name for your shirts. Okay, you're a student athlete. You're like, hey, I'm known by T Markey. I'm gonna come up with my brand of shirts. It's called T Markey. And so you apply to register T Markey as a brand name for shirts, and the examining attorney looks in our database and she finds T Markey has been registered for pants. Are you gonna get a likelihood of confusion refusal? Yes. Oh, thank you so much. I was nodding my head, so I was hoping you guys were getting the clue, okay? I'm not trying to bait you, okay? Right, so you're absolutely right, right? Yeah, these trademarks are similar, and in addition, we know that pants are related to shirts. There's gonna be plenty of evidence that's out there the examining attorney is gonna find to show shirts are related to pants, so no way, okay? So what if we change up the hypothetical a little bit? And you're applying to register T Markey as a brand name for pants, but in the database is T Markey registered as a brand name for pants. Sorry, you're doing shirts. Is this going to be a problem? Are you going to get a likelihood of confusion refusal here? Yep, still not baiting you. The answer is still correct. Okay, yeah. All right. So again, right? T Markey versus T Markey. They might not look alike, but they sound similar, right? So it's still going to be a problem. Okay. I only have 10 minutes. Are you telling me? Okay. I saw you waving at me. Okay. All right. So let's change it up one more time. Okay. I'm not going to give you any clues. You want to register T Markey as a brand name for shirts, and in the database is T Markey registered as a brand name for golf flags. Anybody think there's a likelihood of confusion here? Ooh, I got a maybe. I got a maybe. I got a maybe, I got a maybe, I got a maybe over here. I'm gonna get one more, I'm gonna get one more, I'm gonna get one more, here we're gonna go. Okay, so, all right. So that's, honestly, folks, I don't know the answer here, okay? My guess is the maybes are correct, and my guess is probably the no's are also correct. It's probably not gonna be a problem here, but it's really gonna boil down to the evidence. Can the examining attorney find evidence that companies who, you say, you think so? You're like, oh yes, I agree, okay. There's definitely evidence. Okay, so we've got a very solid answer over here that says that companies that make golf flags also have branded shirts. Okay, so in this case, if she was the examining attorney, she's probably going to refuse registration because she's found all this evidence, right, that people who do golf flags also have branded shirts, or that people who do shirts also have branded golf flags. Again, I don't know. I haven't done the research, so I'm not really sure. But that's okay. I got two hands. We're gonna come back to you. Okay? I was just gonna disagree. Oh, in which case, Amanda, make sure she gets the mic. I want to hear this.
No, it's like the sports equipment category, whereas they're not necessarily doing that.
All right. So the disagreement was in this case, they're two unrelated.
Yeah. I just think that it's worth bringing up that there's a counter argument there.
I totally agree. There's absolutely a counter argument here that companies that do golf flags don't do branded shirts. Now they might have their salespeople run around the golf course and like, oh, I've got my little polo, right? But they might not have a brand of shirts, right? You're not going to walk into a department store and like, hey, you guys carry those T Markey brand? Probably not, right? I don't know. So it's a great point. And again, this goes to the work that I would encourage you to do as an athlete or someone who's working with your kids or your grandkids or your niece or nephew or whoever it is, think about these things, okay? Think about that relatedness issue. Think about that likelihood of confusion issue. Am I too close to somebody else's? Am I gonna actually be able to protect this thing that I'm pouring my heart and soul and money into? Right? Yes, I'm getting 1,000 through this NIL contract and I want to put it back into potentially protecting my trademark. Oh, wow, now I've gone and wasted it because I was trying to register, whatever, and it's too confusingly similar to somebody else. Yes, you have a question?
Yes, I just don't know how loud this is going to be. I do think that the first person over there, I think that's the more correct answer in terms of, my guess is like Nike and Greg Norman, there are people who offer both of these, or brand sources. But what I was going to say is, does Costco sell both of these things? And does Amazon sell both of these things? And I think there's a lot of static that comes up that way because these private label companies start selling so much, and whether or not that's really a source identifier. So my idea is, I think, like a false issue. Or I think it's going to need to be sorted out in time because, yes, Amazon is going to try to touch everything, and that's not right. But I like that answer better.
Cool, right on. I love it. This is, I don't disagree with any of the comments that have been said here today. I think they're all equally valid. And it's really gonna, of course, depend on the research and what does happen in commerce. Now, oftentimes if something is like, part of a huge department store where everything is, they sell everything. Well, that's not really, as consumers, we're like, I don't really think about that as a, house brand sort of thing. Even like your Walmarts and your whatever, your Targets and stuff like that, they have a sub-brand that they usually use. So anyway. Excellent. Okay, yes, one more.
Yeah, this also goes back
They're going to kick me out here in a few minutes, okay? Just want to let you know. All right.
I'll make it quick, but this also goes back to the common law rights I was talking about. Like, let's say they're selling golf flags, right, that say T Marquee, and like you mentioned, they have their own personnel wearing the shirts. But if they're not selling those shirts in commerce, then is it technically a likelihood of confusion because there's no actual sale in commerce?
Correct, because they're not actually using them as goods. Yes, that's an excellent point. Yep. All right, cool. All right, we got to move a little bit, okay? No, trust me, I love these questions. I love when I'm in a smart room. I love it. Okay, another thing that you also want to think about is making sure that your trademark is going to be distinctive. And one way you go about doing that is making sure that your words are, and your stuff is, source indicating, okay? So one of the other reasons, among several more we're not going to have time to talk about today, that your trademark could be refused registration at our office. She's like, what? Talk about them all. Please. Okay. Well, one of the reasons your trademark could be refused registration is because it merely describes your good or your service. So this is an example. I don't think I have a generic one in here. Let me give you a generic example would be, let's say I'm a university and my brand name is University. Right? And my services are educational services at the university level, right? That's not indicating source, okay? That's just telling you what it is. It's a university, right? So generic terms that name for a thing. My brand name is remote control, right? Nope, never gonna work, right? It's just telling you what the thing is. Very similar to that are descriptive trademarks in terms of distinctiveness. Something like college football playoff is actually going to be descriptive of, I don't know, a college football playoff, right? It's telling you exactly what the services are by virtue of the wording itself. Now, in this case, they were able to register it here because it's a combination of wording and a design, and they can disclaim the descriptive wording, let the logo carry it, and things like that. But I want you to think about that, right? If you're like, good basketball player, right? It's going to be pretty descriptive of a good basketball player, right? So maybe that's not something that you could protect. So you might want to think about other stuff which is distinctive, things that are fanciful, like made-up things, made-up words, like hokey. Now, hokey bird, for you Virginia Tech people out there, they're like, no, that's actually a thing. No, it's actually made up. But the hokey bird, the turkey we see now, that's called a hokey bird, but hokey itself, totally made up. Buckeye. So the deputy director has left, so he doesn't get the virtue of me sucking up to him by talking about the Ohio State Buckeyes. I kid about that. I'm actually from Ohio, and I grew up as a Buckeyes fan, so that's why that's up there, okay, you guys? Jeez. All right. So, but if you think about Buckeye, right, which is a poisonous nut, okay, that's arbitrary when applied to, say, collegiate athletics. All right, so stuff like that. Most of the time, your mascots are going to be arbitrary. It's buffaloes. It's lions. It's tigers. It's whatever. I'm not going to say wolverines. Okay, so that arbitrary sort of stuff is going to be. Those can be incredibly strong and very distinctive, and also suggestive. These are also things that you can register with us if it suggests something about the underlying good or service, but doesn't describe it. So you can see here Sweet 16 for organizing and conducting sporting events. Anybody know who actually owns Sweet 16? No, it's actually the Kentucky High School Athletic Association. They actually came up with Sweet 16. Now the NCAA also has, NC2A, however you like to pronounce it, NC2A Sweet 16. They also have a registration for that, but actually the Kentucky High School Athletic Association were the first ones, and so they have an agreement with them that they can have NCAA Sweet 16 registered. And it's really suggesting what's happening here in this tournament is you get down to like 16 and then Elite Eight, Final Four, and so forth, right? So these are all examples of distinctive trademarks, which are things that you can register with our office. They're not going to get refused for being descriptive. Make sense? Yes? Okay, cool, good. The other thing, I know I'm getting close on time. You do want to be careful that you're not just using your trademark in an ornamental fashion, and you're actually using it as a trademark. When we say ornamental fashion, that's usually when it's like splashed across the front of the shirt, it's a repeating pattern all over the place, maybe it's wrapped around the shirt. That's typically considered to be ornamental. If you want to use your trademark ornamentally, cool, that's up to you, that's fine, but it's not technically trademark use. Here, as you can see, you get the block O for Ohio State. When you're wearing it, it just means like, I support the Buckeyes. Hang on, Sloopy, go Bucks. Right? So, it doesn't necessarily mean that, that you think, oh, this is an Ohio State shirt. It's just branded that way. Same thing with the, it's kind of hard to see here, with the little footy pajamas. That has the NC logo there for UNC. Right? So here, these are going to be refused by our office as only being used ornamentally. So what you would want to do is make sure that you are using it in a traditional trademark way. On shirts anyway, we're talking about the left breast pocket area. That is neat and discreet logo. That's good stuff right there. Same thing you can see in the NC there for, no longer footy pajamas, but a different NC pair of pajamas, right? So totally fine. A lot of times people think about just do it, right? Is the Nike slogan, and they see it all the time across the front of the shirt. Jason, it's registered. It's got to be fine. No, they're using it ornamentally. They're using it correctly as a trademark somewhere else. So it's totally fine if they want to put it ornamentally across the front of their t-shirt, but they've got good usage elsewhere. I see your little Nike swoosh right there. Yeah, yeah, right? Good trademark use. Yeah, you came in today knowing, you know what? I know I'm going to get called out here, so I better wear a good trademark thing. So yes, exactly right. Make sense? Okay, so totally fine. You want to splash it across the front, across the back, whatever, that's okay, but just make sure you have good trademark usage elsewhere. There's also a thing called secondary source where, sure, you want to use it ornamentally, just make sure you've got evidence that you are using it in a correct sort of trademark manner elsewhere, or maybe you already have a federal registration for it. Okay, 3 trademark takeaways. I see I'm getting close. I got 2 minutes? More? 5. Ooh, sweet. Cool. I actually have 5 takeaways. Okay, good. 3 trademark takeaways. Remember, trademarks provide legal protection for your brand. You want to create a trademark that is both federally registrable and legally protectable. And if you want help, we always recommend working with an experienced U.S. licensed trademark attorney. That's a lot of words, but let me say them again. An experienced U.S. licensed trademark attorney, okay? This is not some rando that you find online who has a TikTok that you thought was cool, okay? We're talking about like that person may be great, right? But they might not know what they're talking about when it comes to federal trademark registration. So you wanna make sure you're working with experts, okay? And the only people who can represent you before the office are you as the brand owner or the U.S. licensed attorney that you have hired to represent you? Okay, there are lots of people out there. Same thing is going to be true in the NIL space. Oh yeah, here man, let me help you with that. Nope. Okay, you want to make sure it's a U.S. licensed attorney, and specifically someone who does trademark law. What I like to tell my buddies is like, don't get arrested because I cannot represent you in court. Okay, I don't do criminal law. All right, I don't. Right, so you don't want to come to me to have defend you on a murder charge. Okay. If you have a trademark question, I will bore you to tears with an answer, okay? So you wanna make sure you're working with an expert who understands the law. Same thing is true, right, when we're talking about contracts, NIL contracts. You wanna make sure you're talking to a contract lawyer, right, who sees the things that aren't in the contract, which might be a problem for you. Here's the bonus takeaways. Just keep in mind that not everyone needs a federal trademark registration. Sometimes people think, oh, I've gotta get one, I have to have one. Well, maybe. Right? It really kind of depends. I mean, are you going to continue to use this trademark that you have right now as at the university level? Are you going to continue to use that? Are you going to go pro? Right? Are you still going to need it? Maybe, maybe not. Right? Page buckets? Maybe. Right? Maybe it's going to be a thing. Who knows? Right? So you want to think about, I've got a limited amount of time, right? I'm a student athlete, and I do have a limited amount of time. Thank you for the 2 minutes. So like I'm only gonna be here for a little bit. So maybe federal trademark registration of whatever you're using now is not the thing for you, but this is all stuff that you should be thinking about because as you have heard all day today, you are a business. You are an entrepreneur. So even if you're not federally registering your jersey number right now for some various thing that you are doing, the concepts that you are learning today and that you can learn through all the various resources that we provide as the USPTO or through a law school clinic, right? That information is going to help you as you are transitioning out of university and into maybe starting a business. Right? You're like, oh, right, I got to get, that's right, I've got to get financing, permits, business plan. Got to start thinking about that trademark, right? So this might be stuff that even if you don't need it right now, is stuff that's going to help you in the future, right? There we go, I jumped it, but you might not need one right now. All right, so in my remaining probably 1 minute at this point, let me just hit you with some resources. So we have all sorts of stuff that we try to provide to people, no matter where you are and how you like to consume content. We're working on trying to give you more stuff so you can learn the things that you need to learn. So if anybody wants to, I think there's postcards in the back, is that right, Ann? Okay. Okay, so there's flyers all around. You can also scan that QR code right there, and it is going to download a PDF to your mobile device. Okay, and it is called our Trademark Basics Registration Toolkit. It's going to talk you through even more stuff than I talked about today, links to resources and things like that. So I will hold it up there for one more second so you can scan the QR code and scan. She's not even paying attention to me. Okay. All right, so if you want to talk to an actual human, you can call our Trademark Assistance Center. They're our customer service folks. They do want to talk to you, right? And they're actually humans, okay? They're not robots. And so they do want to talk to you. They cannot provide legal advice, but they can answer general trademark questions and point you to resources. Just keep in mind that we don't provide legal advice. We can't help you enforce your legal rights, and we cannot recommend specific private attorneys. Okay, so, but our job and my job for my team, what we want to do, working in conjunction with other folks here at the USPTO, is to make sure we're pushing out trademark information. I'm going to be around today. If you have questions you want to ask me, hit me up, okay? And make sure, check us out on the website. There's a lot of stuff that you can learn that way, even if you don't need it today. Oh, right, I have to do this too. Please beware of scams, okay? They are brutal. Okay, and people are getting hit at all stages of the process. I don't want you to fall into one of these traps. People are losing thousands and thousands of dollars, okay? So if you are dealing with someone, make sure the person actually is a US licensed attorney, or make sure you're actually talking to us. I will tell you really briefly, sometimes what happens is people are like, oh, I'm not a good graphic artist, so I'm gonna hire one online. But it turns out the graphic artist that they hire to design their logo is actually part of a scam network. And they're like, hey, you now have a logo, you should federally register that. Why don't you go over here and they can help you out? It's a scammer, and they end up taking you for thousands of dollars, and you think you're working with us, but you aren't. Okay, you think you're submitting something to us, but you aren't. You're giving them money and it never comes to us, right? So please, please, please be very, very careful about all these things. I just want to make sure that you don't get taken, because it's bad out there. Oh yeah, last one. Okay, just some things for you to think about anyway in terms of scams. We have lots of information about it. I'm really ending this on a dark note. All right, guys. I hope you have a great day. I'm done. Thank you all.
Okay, here we go. I want to point out, first of all, we're not going to be nearly as funny as the prior speaker. There's no way. So we are kind of the nerdy panel at the end of all of this, and the point is to discuss some of the very pressing issues that are going on around the issue of NIL. I'll call it clear air turbulence. It's interesting to hear myself feeding back. Doesn't confuse me at all. But as much as we talk about NIL and what NIL is, the issues we're going to be covering today really are not issues about whether the athletes can. Is there any way we can deal with that? Okay. Like talking to AI, yeah. So we're going to be, because the right for the issue really was not the ability of athletes to be able to, in the theory, to have NIL rights. Those are well established under state law, right of publicity. But the problem was the universities and high schools, but we're principally talking about universities, wouldn't let them exercise the right. And that's what led to a lot of the litigation and led to the legislation that Nancy Skinner introduced in eventually almost every other state. So what we're going to talk about today, the big elephant in the room, of course, is the House settlement, and that's where we will start. Also, though, as Nancy Skinner raised, there's an issue running in parallel about whether student athletes are employees of the university, and if they are, what are the ramifications around that for NIL, both positive and negative. And then, of course, there's the question, notwithstanding all of the academic thinking and acting in this area, what might happen with the new administration that controls the Senate, the House, and the executive branch, because the possibility of legislation that will come in and deal with some of these issues is also a definite reality. And then finally, but not last, is the whole question of Title IX that Nancy Skinner also raised, and how Title IX cuts through a lot of the issues we're going to be talking about. So we're going to start with our panelists, and I'm going to introduce both of the other panelists for you. Dan Rasher, who has his PhD in economics from Berkeley, is professor at USF in sports management, and has the unique qualification of having been an expert witness in the O'Bannon, Alston, and the House settlement. So we have real expert here to help us think through those. And then Trina is a deputy Title IX coordinator for USF. She has a BA from Yale, where she ran cross country and track, and also a master's in education from the University of Pennsylvania. And she is also, not that that's not enough, she is also a third-year law student at USF Law. So what we're going to do is start with Dan and talk about the House settlement, and we'll take questions as we go along. It's too hard to wait till the end. So that will be our format proceeding. So Dan, I turn it over to you.
Thank you, Roy. Is this on? Yes? Very good. So I wanted to step back a little bit and talk about how we got here. And we saw a timeline earlier today, and that covered some of these aspects. But I wanted to sort of dive into how those cases sort of built and led up to where we are today. And then I'll talk about where the settlement's at. So about 20 years ago, some of you may remember Jeremy Bloom, right, was a professional skier for University of Colorado, but he also played on the football team. And he had what I think he thought was a simple request. Well, can I earn endorsement money for skiing? It's separate. It's off campus. It has nothing to do with my college sports, but also play on the college football team. And so he went, the NCAA said no. And so he sued and unfortunately, from my perspective, lost at that point. And I think that sort of ended that for a few years. But about 4 or 5 years after that, Ed O'Bannon, the basketball player from UCLA, his son saw his image in a video game, right? Saw a left-hander with the knee brace, the headband, the whole thing. And he's like, Dad, that's you on the UCLA team in the EA video game. And Ed's like, I don't remember ever giving those rights up, right? And so he ended up contacting an attorney in Washington, D.C., and launched the O'Bannon case, which was filed in 2009. That finally went to trial in 2014. There was no damages class. There was sort of a sister case, Sam Keller, a quarterback at a couple different schools. That case settled on the opening day at trial. I remember, like, as soon as trial started, all of a sudden it stopped. We have a settlement to announce in the Keller case. I think it was between $40 and $60 million. But that was sort of for use of name, image, and likeness in those video games. But this case then proceeded against the NCAA. And the court found, and this is Judge Wilkin that Senator Skinner was talking about, right? She's been the judge in each of these cases since the O'Bannon case. And, you know, a little side note, I think what was really beneficial from the player's perspective about having Claudia Wilkin as the judge was that she had no knowledge or interest about college sports. And she said that. She's like, I have no interest, And so from the player's perspective, she wasn't sort of already bought into the way I think we would all have been brought up, which was, of course, the athletes are amateur. That's what college sports is, right? And we all sort of believe that. And so anyway, that trial ended with the some pretty major findings. Again, I'm not a lawyer, I'm an economist, so but I don't know exactly what the precedent was, but basically that the NCAA was anti-competitive, was violating the antitrust laws, and that the athletes could be paid a bit more money than they were. So the old scholarship was sort of room and board and books, and tuition, and then this added on the cost of living or the cost of attendance, that additional $3,000 or $4,000 that the NCAA used to call laundry money. So they used to allow those payments to come from the schools up until the early 1970s, and then they got together and said, let's cut costs. And if you follow antitrust law, you know that you can't get together with your competitors and cut costs and agree to cut costs or lower or raise prices, or agree not to hire each other's employees, right? We've seen that in the tech industry. And so that was sort of from a practical perspective, that was the outcome of the O'Bannon case. Besides the legal findings, from an economic perspective, the schools were allowed then to start paying the athletes a bit more money. And so as an economist, we watched to see what the market would do. If the athletes earn more money, would the fans stop watching? Because that was sort of that was what the premise was, that the NCAA would maintain, that why we have to have amateurism is that the fans want us to have amateurism. That's what we sell. That's what they buy, right? And so, of course, we saw schools immediately start making those cost of attendance payments because they compete with each other in order to get the athletes. And there was no drop in demand, and we kept measuring and watching and watching. And so right around the time of that trial in 2014, the Alston case was filed. Sean Alston was a running back at West Virginia University. And that case was sort of taking the next step from O'Bannon and saying, now we're going to challenge the collusions across the schools in general in order to cap athlete pay. So the O'Bannon case was quite, I think, inventive from again, I'm not a lawyer, but from a legal perspective, because instead of taking amateurism on head on, they said, let's just say the athletes can be paid for the use of their name, image, and likeness. We're not paying them to play the sport. We're paying them because they have a right of publicity. And the beginning of that case really did, I remember, get messy with right of publicity. And we were looking at different state things, and I was an economist. Could I measure in each state what the harm would be? And then that part sort of moved to the side, and it became a case about competition. Sort of regardless of what the state laws are, the schools will compete, and they will find a way to compete with each other above and beyond whatever those state laws might be. So if one state says you have to pay someone for the right of publicity, and another state says you don't, the schools in that state will anyway. And so we see this in professional sports. If you look at the collective bargaining agreements, they don't really admit that the players have a right of publicity with respect to broadcast payments. They just say, we're going to pay you 50% or 51% of the broadcast dollars. So I thought that was an inventive way in the O'Bannon case not to go head on. But once that was won, then the Alston case did attack head on, initially attacked head on. And so that case, we ended up with a settlement which was looking at, now that cost of attendance payments were allowed, as of, I think it was the summer of 2015, if I remember correctly. Once we watched those payments go, then it was past damages for the statute of limitations of those past 4 years of damages. So we had a settlement in that case prior to trial of around $208 million, which was about 96% of what I was going to testify to anyway at trial. So it was quite a high settlement in terms of sort of meeting that dollar amount. But then what was interesting about that case was that it ended up going, obviously, to trial on the merits. And as many of you probably know, the plaintiffs won. The plaintiffs won again on appeal, and then the NCAA appealed to the Supreme Court. And this Supreme Court, as maybe divided as it might seem, ruled 9-0 in favor of the athletes in that case. So some of the tangible, I'd say, economic outcomes of that was then after the Supreme Court case, then the schools were allowed to pay unlimited payments that are tied to education to the athletes. And so I still think that's something that people forget about, right? The school, if I've told my students this too here at USF, when you were an undergrad playing your sport, if you somehow had the leverage to tell the school, I might go to law school one day, I might go to sport management program, maybe I'll get a medical degree, that school could offer to pay for that, even if you're not doing it at that point in time, right? It's payments tied to education. So people have sort of asked the NCAA and sometimes the plaintiff lawyers, what's the scope of that? And I don't know that scope has been defined, right? I think it's sort of still out there, but
it went fallow because the NIL came, superseded it, and just disappeared.
Right. So 10 days, and so then the other tangible outcome was that and I think one of the earlier panels talked about this, the $5,980 payment that the schools could give the athletes as an academic achievement award, right? The reason that Claudia Wilkin came up with that number was if you look in the NCAA manual and you sort of add up the amount that an athlete could get as an athletic award, it turns out the fans must not be against that because the NCAA already allows it, so we can also make that an academic award. And so once that was allowed, schools started to line up, sort of starting where you'd imagine in the SEC schools, and it spread pretty quickly within a couple years, and they started making those $5,980 payments to athletes depending on if they satisfied those academic requirements.
I just want to add one point, Dan, without interrupting, and that is that O'Bannon and Alston did not actually confer NIL rights. it conferred antitrust damages in the form of these payments Dan described. And it was Nancy Skinner's legislation, which came in 2019, that actually is the operative legal place where the players have gotten NIL rights, because her legislation effectively said it is illegal for California universities to prevent players from monetizing their NIL rights. So you have to read these two antitrust cases in conjunction with the state legislation, which of course quickly spread across the entire country, to get the full picture of NIL.
Yeah, and the timing was really interesting, right? It was in the middle of June when the Supreme Court came out with its ruling, and I think the NCAA was, if they had won, maybe they were going to start pushing back very quickly against all the NIL laws and everything in the different states. But since they didn't win, then they sort of threw their hands up, and as we know, they had 10 days or whatever to come up with the NIL policy, even though someone said they've been on notice since the turn of the century, which is maybe true, but they at least have been on notice since 2009 when Ed O'Bannon filed an NIL case against them, right? But anyway, so then we moved forward after the Alston case, and then we fairly quickly until we watch NIL play out, right? At midnight on July 1st, 2021, right? People started signing deals, athletes were signing deals, and we sort of watched that play out. And so then we have the three cases that are now settling, right? So we have the House case, the Hubbard case, and the Carter case. And so let me just talk about sort of how those developed and then where this settlement came from. And so I'm going to start with the two maybe easier cases, the Hubbard and the Carter case, even though those aren't the biggest dollar parts. So the Hubbard case was Chuba Hubbard, who's a football player, right? He plays in the NFL right now. He filed the Hubbard case, and that was basically for past damages of the 5980. So what was interesting, again, Steve Berman and Jeff Kessler are very smart attorneys, right? They sort of wait 18 months to let something build up. So the economist, has some data to look at. Then they file, so they can sort of get as many years back in the past to collect some damages, but not make it impossible to measure what the damages are. I mean, they've never told me this is their strategy, but if you're just sort of watching, that would be the right strategy. So the Hubbard case is filed, and so it's just looking at past damages, 5980 per athlete, per school in the Power 5 schools. And so the damages were going to be, I measured damages somewhere around, I don't have the number in front of me, but about $280 million, maybe $300 million. And so the settlement is for $200 million. So it's around 64% of the amount that I was preparing to testify to. And so of the $2.776 billion settlement for payments for past harm, 200 million of it, so a small amount, is the Hubbard case sort of coming into this situation and coming towards a settlement. We hadn't quite got the classes certified, if I remember, but we had filed and we were in the process of hopefully getting them certified. And so the settlement talks were sort of happening this whole time. And then the Carter case was filed in 2023. So these are both filed after the House case, which is the main one, but they're a little bit easier to talk about. So the Carter case was just a straight, again, challenge to the collusion amongst the schools. These schools compete with each other in the labor market for college athletic services, and they decide to cap the pay based on their collusion. And you have the collusion. It's not a secret smoke-filled room that you have to go find the collusion. It's written in a book, right? It's this thick. People have talked about it today, right? You see the collusion. The NCAA knows about it. In some sense, I've always wondered, I mean, I sort of get why they want to go to the Supreme Court, because they're like, look, of course we're colluding, but like, we need to know, are we allowed to? Up to what point are we allowed to or not? Because, they have their pro-competitive justifications, amateurism being the primary one. Okay, and so the Carter case, was filed in 2023. The settlement amount is $600 million. So $600 million of the $2.76 billion is for the Carter case, right? And that applies to basically every athlete in Division I, it turns out, is going to get payments for that. And so we're in the process right now of figuring out what those payments ought to be. And so we're using some of the academic literature on the value of athletes to their universities in basketball and in football and other sports to try to sort of parse out that $600 million down to the final athlete. And so that information is going to be completed in about the next 3 weeks. Then we give it to the settlement company, Verita, I forget the name, what do you call those companies, the sort of class action administrative firm. They're going to put it on the website, and on December 17th, athletes will be able to log in and see how much they are owed from the Hubbard case and from the Carter case, right? And then also now, let me talk a minute about the House case. So the House case had moved along the furthest because it was filed in 2020. So it's sort of an old case. And that was challenging for past damages and future injunctive relief, the use of name, image, and likeness by the universities, and preventing the athletes from basically being able to get paid for the use of their NIL, which is what we've been talking about today. And so there's 3 sort of pools of money in that case. The first one is video games, right? So if you, Ed O'Bannon, once, I think this has been mentioned today, once that case was filed, in that process, EA pulled the video game from the marketplace because they weren't able to use the images of the athletes. They wanted to. They're like, who do we write the check to? Is it you guys, the NCAA? Is it the athletes? And we're happy to write the check. We write the checks to the NFLPA. We write the checks to the National Basketball Players Association, right? They wanted to do it, but they didn't, so they pulled it. And so the video game damages are going to total $71.5 million. It's going to be around $600 per athlete per year, something like that. And that's going to all of the athletes in football and men's basketball, because those were what the 2 sports were, in Division I basketball and in FBS football. And that was about 67% of my damages amount. So, for as far as settlements go, that's a pretty high number. Most settlements are down in the 10 to 20% range, if that. Then there's the broadcast NIL. So this is the big ticket item, and one of the professors talked about that today, that's really, the athlete's image is on television, they're running around, it's being used, right, and they're not being compensated for it. And so that dollar amount is $1.8 billion. And that is mostly going to Power 5 athletes because they were the ones that were in the lawsuit. Power 5 football and men's basketball and women's basketball, and some to other athletes. So many athletes in Power 5 football and basketball will receive 6 figures in this, which is an impressive check to get in the mail for a class action, when mostly we get $3.12 for Petco overcharges for cat food once, and we're like, thank you for that. So that's the big dollar item. And then the other one is the lost opportunity, or what's called the lost opportunity NIL payments, which are essentially athletes who, as of July 1, 2021, did start selling their NIL, were getting paid, and could have been paid in the past had that rule not been in place to prevent that. And so that total is around $90 million. And that's based on the discovery that we get in the case. So other athletes can apply under this website and sort of put their information in there. I'm going to be sort of frank here. This discovery wasn't great because the schools aren't collecting all of this information. Like they don't have to collect it. Some states require, but most don't. They don't really want to collect it. The coaches know what it is, but the athletic department doesn't, the school doesn't. So we're out, not we, but the lawyers are getting the discovery and the subpoena and everything. And we're getting good information from some schools, and other schools it's peanuts. So that's about, as I said, about $90 million. So when you sort of add all that up, that's the $2.7 billion, and that's for past damages. Now those payments will be made over 10 years, right? So it's a 10-year settlement with both the payments for the past, but also then the future part, which is, I think, the most interesting. And I sort of can't wait till next fall to see how this plays out. But starting next fall, Power 5 schools and other schools can join in, but they're allowed to spend up to $20.5 million more than they spend now directly on college athletes. Now, they don't have to. That's the beauty of the antitrust laws, right? If you want to compete go for it, but you're not being forced to make payments that you might not really want to make. So $20.5 million across the athletic department. That's going to grow at about 4% a year. So over the time frame of 10 years, that's going to be about $20 billion of payments. But it's sort of like a salary cap at the athletic department level, not at the team level. Other changes, and then I'll sort of wrap up. The schools are going to add more scholarships to most sports, but then they're shrinking the roster sizes. So as an example, beach volleyball is going to go from 6 scholarships to 19, right? But the rosters have to shrink down to 19 from whatever schools might be having now. Men's golf is an example, 2 sports we have here at USF, going to go from 4.5 scholarships up to 9 scholarships. Now, USF may not choose to go up to those numbers, right? They don't have to, right? Universities can opt in to basically this process. And let's see. I think that's it on the sort of summary of the settlement.
Let me hook on to what you talked about with regard to the $20.5 million, because that raises 2 issues I think it's worth going into more. One is the antitrust implications of that, and the other is Title IX implications of that. So I'll quickly address the antitrust. It's very straightforward. You know, competitors cannot get together and agree they're only going to pay salaries up to a certain amount. The way the pros get away with that is through collective bargaining, but collective bargaining doesn't exist in college. So theoretically, even though this is part of a legal settlement, the legal settlement is not binding on parties who are not part of the class. And so you could get other people suing, saying that this $20.5 million is really an illegal salary cap under the Sherman Act. That claim has legs, and it's just going to take a plaintiff's lawyer to file it, and that's not very hard character to find. The other interesting question that I'm going to throw over to Trina is, does the schools who choose to pay out some or all of this $20.5 million, do they have to do it proportionately across all of the athletes, women and men, or can they sequester it for the, let's say, the revenue producing sports, for example? So Trina, take it.
Thank you so much. And it's an honor to share the stage with both of you. I barely made my way through economics courses in college, so I will not be taking any of those questions. For sure, no. Just to back up for a second, I think on the question of Title IX, and I know we've mentioned it a few times during today as part of thinking through gender equity and thinking through the implications, especially NIL and will have for female student athletes or collegiate athletes, is first, that Title IX was enacted in 1972, so we celebrated the 50th a few years ago. It's 37 words. It's very, very brief. The notices that have been put out by the government over the years have expanded the way we understand Title IX and implement it, and especially in athletics, I think there's kind of 2 pieces to it. There's equal opportunity, and then there's equal treatment. And the treatment piece, I think, is what really comes into play, both with the House settlement as well as with NIL. And again, I'm not an expert on these specific aspects of Title IX. My work is mainly in sexual violence prevention, education, and response, but they are intertwined, and especially the impacts for our students on campus. And so on the specific question of the House settlement in Title IX, and Dan was sharing even that they've run the numbers a couple different times, whether does Title IX apply, does it not apply? And I'm of the opinion that these payments as a form of financial assistance must be proportional, and it has to be proportional to the gender ratio based on who's on the college campus. So I think USF we're more like 67. I'm looking at Larry, 67% women. And then, what are the numbers? Do you know? Close enough. Okay. 33% men. And so that means that both the roster numbers have to match that proportionality, as well as the scholarship dollars and the spots that you have for scholarship, as Dan was alluding to. And so I think that there are a lot of folks that would like to argue for many reasons that no, you don't need to apply this proportionately, but it seems that Title IX advocates across the board, myself included, that this would have to be implemented and paid out in a proportional manner if it is seen as a part of this equal treatment, part of these benefits and opportunities, or even just that financial assistance.
Yeah, and there's Trina. I happen to agree with Trina that Title IX is going to require proportionality, but what I think doesn't really matter. It's going to be a lawsuit under Title IX. As Dan said, we're going to find out this fall how these monies are distributed, and if they're distributed, let me interrupt my own sentence with, I was reading the other day an athletic director from a big football school saying, well, we expect to give about 90% of the money to the football team, another 5% to basketball, and then we'll use the remaining 5% as we wish. The legal question is whether that violates, as Trina described it, the equal treatment requirements under Title IX regulations. It's a fascinating question, and it, again, as I said, in the antitrust context, it's only going to take a plaintiff's lawyer to file the case. And so I can guarantee you if a university disproportionately distributes the monies that they're going to get a Title IX claim filed against them.
Yeah, and I would also just add, I think that a lot of folks are thinking through ways that you can kind of get around this requirement by funneling these payments through like third-party entities or thinking about that so it's not coming directly from the university, which of course has to be in compliance with Title IX. And I do think that we will see challenges to that because it will still be considered, coming from the university as well.
Yeah, and Dan, that brings up a question I want to throw back to you as to how the House settlement deals with managing the relationship between collectives and the universities and fair market value tests, all of that. That's a very important part of it.
Yeah, so let me answer that. Let me first touch on the Title IX bit. Even back in the O'Bannon case, again, I'm not a lawyer. As an economist, I'm like, do you want me to calculate this information as if Title IX applied, as if it doesn't? What standard? Is it the current standards, the way the schools spend their money? Because it's not 50-50, it's whatever the numbers are. So we would constantly calculate them. And even the attorneys sort of wanted direction from the Department of Education or from the court. And I think in the end, and I think Jeff Kessler, who's one of the plaintiffs' counsel, said this in one of the hearings, he's like, the schools are complying with Title IX right now because no one's suing them generally, and so they will continue. And like from a player's side, he's like, just comply with Title IX, however you guys are doing that to the schools. And so I don't know how it's going to play out in the fall. I presume you're right. Maybe someone will file something.
Yeah, and I would even add, even in Justice Kavanaugh's concurrence in Alston, he asked the question and specifically he brings up Title IX, says, what sort of compensation regime complies with Title IX? Like, how are you going to do that? So I do think people have opinions about this, but until we see it play out in the courts, or even if we see legislatures enact laws around this, it's going to be a question mark.
So the reason I brought the collectives up is because people have seen the collective as a way to avoid Title IX, because theoretically collectives are not the university and Title IX applies to the university. So the theory is untested that collectives can do whatever they want. And so that's why I brought back to the issue of how their collectives are dealt with under the House settlement.
Yeah, and so Judge Wolkin was concerned that in the first hearing, which was just however many, 6-8 weeks ago, whatever it was, that some athletes would start getting less money because the collectives would not be allowed to pay that money out, right? And so she sort of sent them back to the table, and both sides came with some changes, and they think that the the collectives are still going to be able to operate, right? But the NCAA is going to set up it's claiming to set up a fair market value assessment, right? Anything over $600 has to be submitted. I read that this is beyond what I'm actually working on, but I read that they're going to have to sort of monitor that. How are they going to measure fair market value? I think that's the interesting question. If you get enough deals that are really high, is that the fair market value? And we don't know. The NCAA is really still trying to separate true NIL from what they call true NIL from sort of pay-to-play NIL payments, right? Again, I think on the plaintiff side, they're happy with the system as it's rolling forward, right? Schools are competing for athletes and they're finding ways to pay them. So I think the collectives are going to exist, and they may have a stronger role if they're going to, because they can go above that $20.5 million cap as long as the money's outside of the school. So I think the collective's role is going to continue to be just as important as it has been so far.
And the distinction between what we'll call true NIL and faux NIL is, let's say you play tennis at USF and you'd love to give tennis lessons to high school students, and you would like to put on your merchandising that you are a tennis player on the USF team. That's true NIL. When a booster decides to give $200 to every member of the football team who mentions the booster's company on their social media account, that's what I would call faux NIL, where you're really not providing services or value to that donor. They're just simply subsidizing you, and we're calling it NIL. But we have to keep in mind there's two different kinds of NIL.
Yeah, and I would say we don't have tennis or football here at USF, but one other point I was just going to make, and we're seeing the first NIL lawsuit on the basis of a violation of Title IX play out right now, Schroeder v. University of Oregon, so here in the Ninth Circuit. But this case is I think really interesting because the one of the lead attorneys on it, I have a quote from him. He says, "The complaint does not say independent third parties are violating Title IX." Of course, if we have, Joe's Pizza Shop wants to independently, when I was a student athlete, let's say, give me $100 to, promote the pizza. That, of course, would not be beholden to Title IX. But once the university gets involved and says, "Oh, Joe's Pizza Shop, let me give you these 3 athletes. They're going to be great for your brand. They're going to help promote." Trina loves pizza. I do. And so in that case, the attorney goes forward and alleges that Oregon is violating Title IX because it's working closely with its NIL collective, which is called Division Street, and its own official NIL marketplace called Open Doors to discriminate against female student athletes. And specifically the facts that they allege is that, the football team has, spots 8, 26, 75, and 89 on the highest paid NIL athletes, and not a single woman from University of Oregon is on that list. And of course, Oregon has ties to Nike, and there's all that. But at the end of the day, it goes to that equal treatment arm of Title IX, and they're saying specifically in this laundry list of it's almost a holistic measurement of the ways that athletics departments are treating female student athletes and male student athletes, not assisting student athletes source these deals, not promoting them, that publicity aspect. Schools are going to be out of compliance, and they're going to be found in violation of Title IX. And so I think universities have to be very wary of their involvement with these collectives. We heard from a collective today, and they're very entrenched in the work of these different teams. And so that kind of entanglement becomes an area for vulnerability for these universities. And in some ways, from a public policy perspective, it's unfortunate. We want everyone to be in compliance with Title IX, but I do think the universities and ADs can play a really instrumental role in advising these collectives to do the work that they do ethically, to promote, good deals for students, and the gentleman who spoke earlier talked about having, friendly deals for student athletes. They're looking after them. But I do think that this is going to be an area that is, I see it as risky and will be an area that we want to improve the way collectives are working, so we're not exploiting students and we're promoting good use of NIL, but at the same time, if universities are too entangled, Title IX comes up to play, and of course, I'm of the opinion, as it should, we want to be promoting student athletes and college athletes, female student athletes, in the same way we are, their male counterparts, because I think there is money there as well.
And it's worth noting that under the California statute that Nancy Skinner wrote, California universities and colleges are permitted to make direct NIL facilitations for the students. Most states have a prescription on that, but there are about 7 states, California being the first to have it, so that theoretically Cal or USF or USC or whoever it is could have their own internal NIL payments. But because I suspect, because of these Title IX issues, that's why we've seen these collectives evolve. I'm going to move our discussion because I know you're all anxious to get to the reception afterwards. So I'm going to briefly talk about the employee situation, because that's likewise a burning issue that's going on and does interlace itself with the compensation under Title IX. So back in September of 2021, the General Counsel for the National Labor Relations Board issued an opinion letter to the effect that the General Counsel feels that, and I'm going to interrupt my husband mid-sentence again and say I find this distinction a little bit curious, but this is the distinction that's in the opinion letter, that revenue sport athletes on scholarship are employees under the National Labor Relations Act. And in fact, the opinion goes further and says it's a grievance under the act for the schools to call the students student athletes, because by calling them student athletes, you are inferentially saying that they're not allowed to make money as employees because they're defining them as student athletes. So whether that becomes an active grievance, I'm not sure, but it shows how far this opinion goes. So this, what happened was then the Dartmouth basketball team, for reasons that escape me, decided that they wanted to unionize, even though you recall that Ivy League schools do not receive scholarships. And so the compensation, if you can find it, for the Dartmouth basketball team is gossamer-like. But nonetheless, the hearing officer in that case ruled in favor of the men's basketball team. And so that case is on appeal right now to the National Labor Relations Board. The more significant case, I think, involved the University of Southern California. And that was brought by the College Football Players the College Athletes Players Association as the grievant, claiming that men's football, women's basketball, and men's basketball, those sports only, are employees under the National Labor Relations Act. The hearing has been held, and we're waiting to hear the opinion of the hearing officer. It could come down any time. I'm not sure conceptually why a student who is on the rowing team or the cross-country team is not an employee in the same sense as somebody on the men's basketball team. They work just as hard. They provide just as much effort for the school. But nonetheless, that's the distinction that right now the NLRB is making. So if the interesting problem with this case is, as many of you probably know, the National Labor Relations Act only applies to private employers. So USC is a private university, but if UCLA were included in this grievance, they would not be covered by the National Labor Relations Act. So the way the NLRB is trying to include the public universities in this same theory about students being employees is by considering the NCAA to be a joint employer of the schools, of the students, claiming that the oversight function of the NCAA is so gripping and so precise in its regulation of how college sports are conducted that just like McDonald's is theoretically a joint employer of all the people who work for the franchisees, that likewise all of the athletes for public universities are likewise employed jointly by the NCAA. That theory is not being tested in the USC case because it's not an issue. But if this were to go beyond USC, likewise Dartmouth is a private school. If this were to go to, let's say UCLA or University of California, then the issue of joint employer would be a hurdle that the National Labor Relations Board has to surmount in order not to have a bizarre outcome where you have maybe 3 or 4 teams in the Big 10, I guess they still are, because you'd have UCLA, USC, Northwestern, and I think that's it, right? Those are the only private universities. So you'd have a conference with Northwestern and USC with unionized students playing football, and the rest of them would be outside of the National Labor Relations Act. So as you can see, this is somewhat of a murky area. But it's a very active area and one that we have to keep our eye on.
If I could jump in with a couple points. 2 things. One, I don't think that matters if you ended up with some schools that had employees and some schools that you didn't, because the schools are going to compete. And so I remember in the Northwestern case, I was actually on sabbatical teaching at Northwestern when that hearing occurred. So I went down a few times and was watching in on it. And in that case, the NLRB, I think, also sort of punted and said, well, we don't want to have a chaos in the marketplace where we have some schools have employees and some not. But we have that now with teaching assistants, right? We have that now with other companies that in some companies, we have contractors, right, who do some work. And I know that's a question of whether that's allowed or not. In other companies, you have employees, right? In this case, if UCLA felt like, oh my God, the USC athletes are employees, they're getting something in addition, then UCLA would just give them something in addition. They would fight to be able to do that. So I don't think that's a good enough reason if I'm at the NLRB to say that you couldn't just do it anyway for the private schools, and then the other schools will sort of compete and figure it out. And then my second point, just before I toss it back to you or to Trina, is that if you recall in the Brady v. NFL case, when Tom Brady wanted to decertify the union, this was 20 years ago or something like that. Is it 2011? Okay. So he wanted to basically say, I want access to the antitrust laws. I want to see if I can create competition directly. Everyone's a free agent all the time sort of thing in the NFL. Roger Goodell went back to the court and said, Your Honor, can you please put the union back together? In other words, I think dealing with the union from the NFL's perspective is preferred than having competition. And so that's why I'm curious why the NCAA is fighting so hard to stop athletes from becoming employees. And I think Larry and some others alluded to this today. It might be easier to be able to sort of deal with the athletes as employees. Again, if I'm just thinking from the side of the NCAA and the universities, it might be easier to do that as opposed to now where we have competition. And good luck, in trying to sign that athlete. So again, I'm not an expert on the employee cases. I haven't been focused on those, only on the antitrust cases. But I think that's sort of an interesting maybe flip of what we might normally see with respect to unions and companies.
Yeah, and I agree with you generally. When the NLRB abdicated jurisdiction in the Northwestern case, I wasn't sure that was the right decision. But one of the positive things that the schools could do if their employees are, if their athletes are determined to be employees, is sign a collective bargaining agreement with them, because they're employees now anyway. They got all kinds of rights, everything from Title VII and so forth. So you might as well get a collective bargaining agreement down on paper, and in that you could actually regulate NIL rights, and you could also regulate the transfer portal, which we don't talk about much, but that's, I think, one of the main elements that's creating the disarray in intercollegiate athletics right now. Is a coach recruits a player and then you don't know whether they're going to be the next year, because somebody else will offer them a better NIL deal, so they'll go somewhere else. If you had a collective bargaining agreement with your football team, let's say, you could have put a stipulation in the bargaining agreement that the players agree they won't exercise their rights in the transfer portal. And because collective bargaining is exempt from antitrust laws, you avoid the issue that has led to O'Bannon, Alston, and House, and so forth and so on. So the what they call a non-statutory labor exemption would actually give teams, schools, more latitude to bargain provisions that could bring some sort of order to this chaos that we have right now.
So I just saw we have the 10-minute mark, and we want to make sure folks have time to ask questions, and feel free to jump in at any point here. I was going to touch briefly upon the Johnson v. NCAA case, which just had a decision this summer in the Third Circuit. This is a case that involves the named plaintiff, Trey Johnson, was a football player at Villanova University. He originally filed this, I think in 2019, though maybe I'm wrong there, and essentially is filing and claiming that he should be recognized and the class, that he represents as an employee under the Fair Labor Standards Act, the FLSA. In reading this, in this case, I realized I think I'm actually a member of the class, which is, interesting. I'm like, maybe payout. And really just to give an illustration of the argument that they make in the case, when I was a student athlete, I was on financial aid, and part of my financial aid package included federal work study. And so it was required that I would have to work, or it was suggested I would work, and put into that calculation, I'd work a certain amount of hours in order to make sure that I was, meeting the amount of aid the university was giving me. And what it looked like in the day of life of a 3-season cross-country and track and field athlete would be I'd go to practice, get on a 2:45 or 2:30 bus. It was a 15-minute ride to the field house. I'd practice typically 3 hours till about around 6, take a bus back, go to dinner. And on Fridays, I would actually bartend at the ice hockey games for 5 hours. I would, after practice, would get there straight from practice and be there till about 11:30, and make, I think I made something around, maybe it was like $13.75. I can't remember what the wage was back then. But I did this. And then on Sundays, I'd go to long run. I'd run between 12 and 15 miles every single Sunday morning. And then I would grab food as quick as I can and go work at the dark room, the photography dark room, for 5.5 hours. And I sat there and, I got, I think it was like $75 I started every week in my pocket. But it was a lot, right? And so the argument here is, just like we've had this federal work study system, which has been acceptable and non-disruptive and completely fine for all these years that universities use, student athletes, or collegiate athletes, I should keep correcting myself here, that this is a form of work study, and that there is an academic benefit to bartending at ice hockey games or selling tickets at football games, in the same way that you don't need to find that academic benefit with the work that athletes or collegiate athletes are doing. And so when the case was in the Eastern District of Pennsylvania, they said the NCAA filed a 12b6 motion to dismiss, and the court ruled under a unpaid internship test that no, we're not going to dismiss this based on that. And then, NCAA appealed, and Third Circuit, while they affirmed the ruling, they sent it back under a new test of the economic realities test. And I'm not going to go into all the details and bore everybody, but I think that that's a really interesting case because there have been so many justifications by the NCAA on this amateurism and under the FLSA that college athletes are not employees. And I should also note we have Dr. Molly Harry here, who they cite in that NLRB memo of why we shouldn't use the term student athletes. And I think that this is going to be a really interesting era. The biggest thing I want to just stress at the end of this is that the former NCAA president is quoted in an interview saying that once college athletes become employees, Title IX doesn't apply. And I will say unequivocally, Title IX still applies to employees. I think that we had a panel I was on one year that was called professionalization of collegiate athletes, does Title IX apply? And everyone laughed who was on the panel that was even the title. So I think that's really important to note that even if we see this professionalization, Title IX still applies. It applies to employees, it applies to university employees. So those are some key points there.
And if I can just jump in, it's my understanding too that the athletes at Army, at West Point, at the Naval Academy, at Air Force are federal employees, right? They're all federal employees.
I can't confirm or deny that. I'm not sure, Professor.
Some of the folks here, yeah. So like employees can play a sport and be out there, and it doesn't change the nature of the game. It doesn't change fans' perception of amateurism. It doesn't change competitive balance. It doesn't affect any of those things.
So we have a few minutes left, and the last topic we wanted to delve into is what's the possibility that all of this is going to be obviated by federal legislation? And the NCAA, of course, a couple of years ago hired Charlie Baker, who has a lot of legislative experience, having been from Massachusetts. And that's his main job, I think, is to try to get some order back into intercollegiate athletics. And so because we have a Republican House, a Republican Senate, and a Republican executive, it's not going to be hard to get legislation through. And the committee with initial jurisdiction over this question of intercollegiate compensation is the Senate Commerce Committee, and the chair of that most likely is going to be Ted Cruz. Ted Cruz already has a bill that's been in the hopper for over a year now that does several things. It codifies at the federal level NIL rules so that you don't have 50 different state rules for NIL. The second thing it does is provides in very obscure language, and I think they may try to strengthen this, is an antitrust exemption for the NCAA, so that a lot of the activities that we've discussed involving NIL regulation would be no longer an issue for the NCAA because they would have the only sport that I can comparably compare to is baseball's antitrust exemption that came up under a very bizarre set of facts. This would be a legislative exemption. And the third thing they will do is amend Title IX to deal with the issues that Trina has been identifying. And the last thing they'll probably do is amend the National Labor Relations Act to say that students who play a sport for colleges are not employees. And so if that statute were in place, we wouldn't have this panel. So it's something to keep our eye on, because with the control of the three branches of the federal government now, it's quite easy to pass this. The Democrats had been resisting a lot of elements of this, but now with Cruz running the Commerce Committee, it could well go into place. So that covers our topic. Do we have questions, complaints? Question?
It seems like we have time for maybe like one, maybe two questions.
Hi, I have a question about Title IX. I mean, I want to start out by saying I am a proponent of Title IX. I was one of the people that watched the Women's March Madness this year. And I got to say, I'm a fan of the Oregon State Beavers. I don't know if you guys know who Reagan Beers is. She's a power forward. She did great. So if you get a chance, check her out. Otherwise, my question is, I've had a lot of pushback from universities saying it depends on where the funds come from as to whether or not Title IX applies. They're saying since the revenue sharing is from broadcast companies, it's a third party, so it's essentially it wouldn't apply. I can see a world where, yeah, sure, the broadcast companies give money to the universities, and if the universities then disperse that to the student athletes, Title IX would apply. But if they give all of those funds to the collective, and the collective disperses it, then Title IX wouldn't apply. So I'm trying to find the balance between, because I think you said the financial assistance arm is pretty broad, and could extend to that situation, but I'm trying to figure out the differential.
Everybody's trying to figure it out. That's the bottom line of all of this. There are a lot of ways to circumvent law, and people get paid a lot of money to try to figure out how to get around things. And there's no doubt that the collectives, if this becomes an issue, would figure out a way to perhaps take broadcast revenues, sequester them, and pay them only to the men's football team, for example. I think this is, as Dan said earlier, this fall is going to be 2025 fall is going to be very telling, because we're going to start to see A, how the system works, and B, how people are trying to game the system. So your comment is well timed. We are out of time, and there is a reception, and so if this is where you get free wine and free food and so forth, and we appreciate your attention to this very important topic. Thanks very much.
Thank you.